Marvelous, my lord. My lord, I beg to mention I number 25 in the writ petition number 42. Matter has not been listed. I am praying for listed for tomorrow, my lord.
Single bench.
No, my lord. Double bench. Yes, my lord. It's a matter of double bench. The read appeal, my lord. IA is to be considered only, my lord, wherein only 14 days is to be conducted, my lord.
Okay. Anyway, we'll see. You see. We'll see whether there are other matters tomorrow. If there are other matters, we'll list it. Otherwise, we'll have it on Wednesday. Vanessa, please come.
Sure. Yeah.
Item number 1. Lordship, I was directed to furnish the encroachment list of the encroachment, but then I have received a letter from the officials telling that right now they are doing the election matters, Lordship. So they may be allowed some time. We have filed the affidavit already, Lordship, but then the Honorable Court has directed us to file, Lordship, list of the encroachments. Encroachment.
How many encroachments are there otherwise?
Otherwise, they have given only 3 encroachers here in the affidavit, Lordship. So the petitioner is saying there are more. So
that's why that
yes,
verification is required.
Yes,
According to you, what is known is only about 3 people. Petitioner says that there are more than 3 people.
yes, Lordship.
So court says that you have a verification,
Yes,
submit a report.
yes, Lordship.
And this election is happening when?
Lordship, the election is on 15th, this 15th.
15th.
Yes.
So
Results
15th
will be out on in
in the evening.
19th,
23.
Oh, when?
23,
Sorry?
23,
20, result
20,
23,
20th, Lordship.
20th.
Yes.
Okay. After that, there will be just 3 days left.
Yes, Lordship, can this matter be so?
Mr. Lolan, we have it in January then. Let them
Yes.
come up with the appropriate list.
Lordship.
After the break, Lordship. A bihu break.
Brother?
Yes.
January, no?
No.
See, please write down. By the last court's order, the respondent authorities were required to furnish the list of encroachers of the government land in Tirbin Township after identifying them. So it may be stated herein that according to the affidavit filed by the state respondents, they have found only 3 encroachers on the land in question. But however, according to the petitioner, there are more encroachment than what has been stated in the affidavit. Stop. having regard to such a stand, comma, this court had directed identification of the encroachers by the respondent authorities and for submitting a report to the court. So today, Ms. Arbasar, Ms.
Lordship.
Giate, learned additional senior government advocate, submits that in view of the election process, what is the election for?
Panchayat election.
Panchayati Raj. In view of the Panchayati Raj election process 2025, all the officials are preoccupied in election duty. And therefore, she has been instructed to seek for at least 1 month's time to submit the report. So, in support of our submission, the Learned State Council has produced communication dated 27/11/2025, written to her by the Deputy Commissioner, Leparada District, Basar. Stop. Next para. Considering the above position, we adjourn the matter for 1 month. As paid for, with an understanding that the detailed report shall be ready and submitted by way of an affidavit by the next date. List the matter again. Today is what date? 8th, isn't it?
Yes.
We'll have it on 19th,
Yes, Lordship.
19th January 20, no, make it 20th January 2026. The official respondent shall file the affidavit on or before 19th, 2026 with a copy to the other side. Stop. Next para. A copy of the communication dated 27/11/2025, submitted by Ms. Giate, Learned State Council, shall be kept on record and marked as X for identification. All right.
Lordship.
You are there?
Yeah.
For which respondent?
7 and 8.
Your good name? K. Lolen.
Kirmani Lolen.
He's also Mr. Lolen.
Yeah.
Both K. Lolen. Okay. You said Krimani.
Kirmani Lolen.
Krimani. Can you tell us the spelling? Give the spelling. Mr. Krimani Lolen. Learned Council appears for respondent number
7 and 8.
7 and 8. Anything you would like to submit?
No, today we'll file our.
And submits that they'll be filing their affidavit during the course of the day. Course of the day. Okay.
Obliged.
Deeply obliged.
Item number 2.
May it please the Lordship.
Yes.
This is an issue pertaining to a particular festival of the Nisi tribes.
Mm.
What has happened in this matter is,
Lordship, before my learned friend go ahead, Lordship, I have filed affidavit on behalf of 3, 4 and 5 Deputy Commissioner, and I have received from the respondent number 3 just there before yesterday, on Friday, Lordship. We maybe allow some time from the
You-
Director Indigenous.
You have already filed for 3, 4 and 5.
No, 4 and 5 I have already
that is
filed.
the Deputy Commissioner of the concerned Sagali.
Yes, for that I
subdivision.
have
4 and 5 you have filed.
filed
And now you have received instructions from
from 3. That is
who's the respondent number 3?
Director Indigenous, Lordship.
Director of Indigenous Affairs. It's a department,
Indigenous affairs.
department dealing with the indigenous affairs of the state
Okay, that's
regarding all the
important, I think.
tribals' welfare and all.
That'll be important, I think.
Yes, that's why.
Okay, considering the issue involved. You have received the Parawis comments.
Yes, Lordship. I
When-
just
when-
received on
When
Friday.
can you file it?
Lordship, within 2 weeks. Lordship.
What is the procedure like? You
Lordship.
receive Parawis comments and you file it,
No,
or you draft and you send back for vetting?
for swearing, they have to come here, officer have to
No,
come.
that's all right.
Vetting.
After drafting.
After drafting, whether vetting is required or not?
No,
Not required.
not required.
Good, then I think we can file it within short time.
Officer
I
have
think in
to,
Assam it's different, isn't it?
Assam, we have to do the vetting.
They furnish the comments, they draft it again, they send it to the department,
Yes, because they will have to,
They vet it.
before signing, they will see as to whether it has been drafted
they
correctly or
vet
not.
it, then after that it comes back, then they swear it.
And they might do a lot of modifications also there.
That is there. That takes a long drawn
after
procedure.
vetting, it comes here to us.
That is better.
Yeah.
Yes,
Same
I think
thing
it's
happens in
faster
Mizoram
this way.
also.
Yes.
The law department vets it.
Yes. Lord.
After that, they send it to the government advocate.
Yes.
And they just draft it according to what the vetted Parawis comments are there. And if so required, if some modification is required, then it is sent back by the council. That this
Okay.
point is not clear, that point is not clear.
Yes.
Then they clarify it.
Also, my
So this,
anxiety is this entire festival that we are talking about,
February,
February.
So-
26 February.
Twen-
that is in-
26 February, so we'll have it in
So-
January on reopening. You require only 2 weeks time. I think you have more than 2 weeks now.
Lordship, even in 1 week, I can ready the matter, but then officers, they have to come and it's the same thing. Everyone is busy in election duties also. The government officials.
Do you have any nodal officer for the court?
Yes, in every department.
Every department has a nodal officer.
Yes,
That person can come. You don't have to invite everybody to come and see.
Lordship.
One person will come and swear it under secretary and above, I think.
Lordship.
See, court reopens, in fact, on 5th. Then 6th is a holiday. Then 7, 8, 9 is a working day. So within this 7, 8, 9, you can file.
Filing, I will do Lordship. Can-
Filing if they can do this week, this month in December, as she's saying 2 weeks time.
Hmm.
Then if required, I can file my reply also within that time. And on reopening, it can be heard, Lordship, in admission stage.
Yes, Lordship.
All right, Ms. Jayate, you file it by 24th
Lordship.
with a copy to the other side. You file it with a copy to the other side.
Yes, Lordship.
Then they might file a reply, if so advised, by 9th of January. Then we list the matter on 19th.
Lordship.
All right,
Or Lordship will have it on 20th then, Tuesday,
20, all right, 20, yes.
20th, Lordship.
Lordship,
Yes.
Lordship,
Yes.
I am for respondent number 6.
That is the
Central Yokam Committee.
Yes,
Yes, today I am filing affidavit in opposition.
sure, you file it.
The
Give a
copy to
copy
be
to the other side. Your good name, Mr.
A. Sarma, Lordship.
A. Sharma, Learned Counsel appears for the petitioners. Ms. G. Ete, Learned Additional Senior Government Advocate, appears for the
1 to 5, Lordship.
respondent numbers 1 to 5 and submits that respondent numbers 4 and 5 have already filed their counter affidavit. Stop. Not stop, but, not but, has already filed a counter affidavit, and that she has recently received Parawis comments from respondent number 3,
Yes.
which is the Director, Indigenous Affairs Department. So stop. She therefore submits that she may be given 10 days time to file a counter affidavit of respondent number 3. The prayer is allowed. Then Mr.
K. Posi.
A.
K.
K.
Posi.
Posi, POSI,
Yes,
Learned
POSI.
Counsel appears for respondent number
6.
6 and submits that he will be filing the counter affidavit during the course of the day.
Yes.
We'll stop. Next para, considering the above submissions, the respondent number 6
Yes.
to file counter affidavit during the course of the day, and respondent number 3 shall file the counter affidavit on or before 24th of December 2025 with a copy to the opposite party. Stop. The opposite party / writ petitioners will be at liberty to file a rejoinder affidavit to the counter affidavits, if so advised, on or before 9th of January 2026. Stop. Let the matter be listed for admission on 20th of January 2026.
Yes, Your Lordship.
Much
Obliged.
obliged.
Obliged, Your Lordship.
Item number 3,
Please, Your Lordship.
Yes. What is this matter?
Lordship, it's an appeal against conviction.
Conviction under 302. The paper book is in two parts, is it?
The first part?
Hmm.
Page number 1. The top it's written PA. May I read, my lord?
Page 1.
It's after 3 pages of the paper book. What's the paper?
Yes.
Officer, to the officer in charge, police station 1, question. Appeal for registration of fire against murder case. Respected sir, I have the honor to inform that last night there was murder of my own family member, that is sibling, Rakesh Beong, who was happened at Kola Camp at around 7:15 to 8 p.m. on 18 February 2016. Moreover, we have strongly suspected murder names Ajit Rangmo, Binglu Takyo, Arun Chetri, Sagar Adivasi, and Vikas Boro. Now, this Sagar Adivasi is the appellant here. The rest were not charged. Number 4.
No, the
It's
others were
written-
discharged.
The others, they were not charged.
They were not charged.
Yes, they were discharged.
Discharged.
Yes. Except for serial number 4. Here it is written Sagar Adivasi, but actually his name is Sagar Sabor.
Okay.
We strongly condemn to high-level inquiry on the above names, as he was killed at place Kola Camp near Mrs. Rina Rangmo's residence, and we strongly suspected Mrs. Rina Rangmo, she has involved in murder case because of her activities creates in last night.
Mm.
So they are suspecting Rina Rangmo also, who happens to be the prosecution witness number 1. So we are highly requested to take necessary action against them, those mentioned above. This was registered on 19th of February at 900 hours, and a case was registered, Balopung PS case number 14 of 2017 under section 302/34 IPC. And Inspector Ayete was to take up the investigation. Now, the investigation was done by 2 IOs. The name Mr. Ayete and another one who eventually filed the charge sheet. That is one Duto Bagra. The charge sheet starts at page number 4. The brief prosecution story of the case is that on 19/2/2017 at 900 hours, a written complaint was that on 19/2 received from one Sri Nyokam Rangmo, son of late Mera Rangmo of Kola Camp, Balukpong, to the effect that last night around, that is 18/2/2017, in between 7:15 p.m. and 8 p.m. one Rakesh Boyong was murdered at Kola Camp, and strongly suspects Sri Ajit Rangmo, Sri Binglu Takyo, Arun Chetri, Sagar Adivasi, and Vikas Boro.
behind the murder. On receipt of the information, a case was registered by Balukpung case number 04/17 under sections 302/34 IPC and endorsed to Inspector Iete for investigation and re-endorsed to me for further investigation by number dated 18 September 2017. During the course of investigation, the place of occurrence was visited, rough sketch map was drawn, and photographs taken. Some soil and twig of blood and a twig with blood stain and blood sample collected from the spot, and dead body of the deceased. One gray T-shirt and white ganji and a red-violet color shirt were also seized from the possession of the deceased and suspected Sagar Sabor, respectively. The above collected blood stain, blood sample, and clothes were seized were sent to FSL for chemical analysis. The inquest over the dead body was conducted and forwarded to the Community Health Center, Balukpung, for post-mortem examination. The post-mortem conducted and the dead body handed over to his relatives for last rites. The post-mortem received wherein the doctor Tage Neha opined that the cause of the death is hemorrhage shock due to excessive bleeding following multiple stab injuries on chest, back, neck, and face. The suspects, Sri Ajit Rangmo, Sri Takio Binglu, Banglu, Sri Mintu Bora, Sri Vikas Mahilya, Sri Anand Topno, Sri Arun Ryan, and Sri Sunil Jebiso were arrested on 19/2/2017 and produced before the Executive Magistrate Balukpung on 22/2017 and remanded to police custody for 7 days. Except Sri Sunil Jebiso and Anil Topno, who were released on the same day by the Executive Magistrate being juvenile, Sri Ajit Rangmo was released on 21/3/2017 on bail from the Honorable Court of ADSJ Bomdila. The other arrestees, namely Takio Binglu, Sri Arun Rai, Sri Mintu Bora, and Sri Vikas Mohilya, were released on bail on 23/3/2017 from the Honorable Court of ADSJ Bomdila. On 23/2/2017, the prime suspect, Sri Sagar Sabor, was arrested and is presently in judicial custody. He admitted to have committed the offense. The alleged accused, Sri Sagar Sabor, son of Sri Sagar Suresh Sabor, is the permanent resident of Balukpung, Assam, in Assam Arunachal border near Kolakem, Balukpung. He came back to Balukpung in the month of December 16 from Mumbai, where he was working as a wage worker in cold storage. After coming from Mumbai, he had been staying with one Ajit Rangmo, extending help in his shop located at Kolakem. On 18/2/2017 at around 7:30 p.m., by hearing an unusual sound coming from outside of our house, Srimati Reena Rai, wife of Arun Rai, came out of his house and found a man lying on the ground. She immediately informed his husband, Sri Arun Rai, and his family, friends, namely Vikas Mohilya, Sri Takio Binglu, Firoz Khan, Kumar Konjuju, who were sitting nearby under construction SP-type building. They rushed to the spot and found late Rakesh Beong badly injured and lying on the ground. The victim, late Rakesh Beong, was evacuated to Hope Hospital, Balukpung at 7:33 p.m. and doctor declared him brought dead. During the investigation, it was found that the alleged accused, Sagar Sabor, Sunil Jebiso, Mintu Bora, Takio Binglu, and late Rakesh Beong had a local beer at a place called Atopong, located in Kolakem. In addition to the local beer, they also had ganja. Bang, the local beers brought by them were finished and they wanted more. Hence, Sri Mintu Bora was asked to fetch more local beers by late Rakesh Beong, but Sri Mintu Bora handed over the money to alleged accused Sagar Sabor for fetching more local beers, which he refused. By seeing the refusal from Sagar Sabor to fetch more beers, Rakesh Beong got annoyed and slapped twice in his face. Sri Sagar Sabor also retaliated, but it was stopped by the other friends. Within brackets shall be proved by witnesses 4, 5, and 7 in witness column. After having fun at Atopong, they left for their own houses in the evening. In between 6 and 7 p.m., Sri Sagar Sabor came back to the shop of Ajit Rangmo, and after a few minutes, the deceased late Rakesh Beong also came and left the shop for his house with a cigarette. As soon as late Rakesh Beong left for his house, Sagar Sabor also left, telling Ajit Rangmo that he is going to visit his mother. There are two routes which lead to the house of late Rakesh Beong. One of the routes is towards left and other is towards the right of the shop of Sri Ajit Rangmo as shown in the construction sketch map of the, this is not very visible, scope of time, I think. Late Rakesh Beong, victim, took the route towards left and alleged accused Sagar Sabor took the route towards the right. Within brackets shall be proved by witness number 6 in witness column. Instead of visiting his mother, alleged accused Sri Sagar Sabor turned towards the route which leads to the house of Rakesh Beong. On the way, he found Rakesh Beong and assaulted him with a knife, due to which Rakesh Beong sustained multiple stabs and incised injuries on his body and fled away. As disclosed by alleged accused, after committing crime, he took the route that passes through the Sunday market and leads to the highway. On the way, he threw away the knife at Sunday market area. The efforts were made but could not recover the weapon of offense since there was a Sunday market on the very next day. After reaching the highway, he went to the shop run by Sri Narayan Sharma with blood stains on his face, on his hand, face, body, and clothes, and asked him for a biscuit packet and a cigarette. The owner of the shop gave him the biscuit and a piece of cigarette flake, and when he queried about the bloodstain, it was told that he had a fight with a boy, which was fully corroborated with the statement of Narayan Sharma. The shop owner, alleged accused, led the police to the shop as per his disclosure. After that, he proceeded further on foot towards Thursday Market through footpath route and had stolen a jeans pant seized and identified by the owner from the house of Rahul Narzari. Accused led to the house from where he had stolen the jeans long pant. After that, he went to the bank of River Kameng and washed himself. He thrown all the clothes into the river which he wore during the committing of the crime, except his t-shirt, and sent to seize and sent to FSL. After committing the murder, he has been absconding. On 23/2/2017, he made a call to the mobile number of Ajit Rangmo to know about the health condition of Rakesh Beong. In order to get him back at Balokpung, Sri Ajit Rangmo told him that Rakesh Beong is admitted in hospital. After hearing this, Sagar Sabor came to Balokpung and met Prasanta Bora, father of Mintu Bora, and came to know that Rakesh Beong is no more. Hence, he decided to surrender before the police. But while on the way to the police station, along with Prasanta Bora, he was caught by the sister of Rakesh Beong and handed over to the police. Further, alleged accused Sri Sagar Sabor disclosed that Rakesh Beong used to humiliate him whenever they met. He used to scold and show his superiority to him, which he didn't like. On 18/2/2017, he was humiliated and assaulted before his friends by the victim, late Rakesh Beong, which consequently led to the murder of late Rakesh Beong. Further, it was found that the arrestees, namely Ajit Rangmo, Mintu Bora, Takyo Binglo, Sri Sunil Jebiso, Arun Rai, Sri Bikash Mahalia, and Anand Topno who were arrested on suspect are not involved in the instant case. Hence, the Honorable Court is all the liabilities. Under the facts and circumstances, a prima facie case under Section 302 is well established against the alleged accused Sagar Sabor. Hence, he is sent to the Honorable Court to stand trial before under the appropriate section of law. So this is the charge sheet. Now, my lord, to prove this, there were 17 prosecution witnesses, out of which, like I said, 3 were seizure witnesses. The statements of according to the FIR, it's 18 February 2016.
17.
It is written 18.
Okay, it should be 17 actually.
In the FIR, happened in Kola came at around 7:15 to 8 p.m. on 18 February. On 19.
The FIR says that incident happened in 18 February 2006.
Yes,
It's
2016.
wrongly mentioned, madam.
The right copy.
Yes, madam. The first page is the type copy, madam.
It's a type copy.
First page. The second page is, even this is also the type copy, madam. The FIR registered by the police, madam. There, the date of incident has been mentioned as 18/2/2017.
This must have been in handwritten. If that can be,
Certain from the record.
if it can be ascertained from the record, Lordship.
Joseph mentioned 18 to.
Yeah, 2017. Charge sheet is fine, my lord. Only in FIR.
Just check up
Yes, ma'am.
what is written in the original FIR. We do this.
My lord.
So there is no rightness in this case.
In the original FIR also is written 2016. I have a copy. Yes, it's handwritten. Yes, it may be in, my learned friend may check from the records. Before proceeding, my lord may note one thing. The seized items, they are saying they have seized one T-shirt from the accused, alleged convict. Now, that FSL report is not there. Number one. Number two, some slipper and some things were seized that was not belonging to the accused, belonging to some friend who was there to evacuate the dead body. Seizure list, your lordship will find at page 27. I'll show from the evidence later on also, but this just to note this fact, lordship. So far as material things are concerned against the accused person, there is nothing. Then lordship may come. Sorry. इस तरह से है, देखो. PW1, lordship, page 72. Page 72. She was the person near whose home the dead body, the injured deceased was found. PW1, Reena Rai. May I read, my lord? On oath, she says, I have been examined as a witness in connection with murder of deceased Rakesh in 2017. Deceased was my neighbor. I heard a sound like vomiting of a dog. So I came out from the house and noticed a person lying on the road. I came close to the person and identified the deceased Rakesh. I called Binglu by name, who was present in a house nearby the PO. He came along with the other boys and found blood on the body of the deceased. The boys evacuated the victim to the hospital. The deceased was not in a state of speaking. I informed the relatives of the deceased was alive till he was evacuated to the hospital. It was evening time, but I cannot exactly say the time. After the death of the deceased, police arrived in the hospital and recorded our statement. I have stated the same thing which I have deposed. Police arrested all the boys who evacuated the deceased to the hospital and also my husband. Her husband is Arun Rai. My husband was also with the boys who were present near the PO and busy in merrymaking. I recognize the person standing on the dock. He is Sagar Sabor. I know him long time back. The accused was suspected to have committed the offense as he had quarreled with the deceased on the day of the incident. After consumption of alcohol. Later on, he was arrested by the police. Then in the cross, she says, I did not interest to call my husband as I had quarreled with him in the evening. The PO was at a distance of 22 to 25 feet from the place of merrymaking by boys. The deceased body was hardly a distance of 12 feet from my house. The sound of the deceased cannot be heard from his house, which is about 40 to 50 feet. The mother of the deceased was not present, so I informed the other relatives. The medical is located within 1 km from the PO. I heard from Mr. Binglu, that the accused a quarrel with deceased during the daytime on the date of the incident. I did not hear the reasons of quarrel. There was no dog nearby the deceased body. I have not carefully noticed the portion of the body where bloods were oozing out. I did not see the injury. I did not see the incident of causing hurt of the victim. So, just to establish the story which the prosecution has been projecting, number one, the deceased was found at a distance of 12 feet from her house, injured. The other boys who were merrymaking in the half-constructed building, as mentioned in the chart sheet also, that is around 20 to 25 feet. And then it was evening time when the time has not been specified, but she says it's evening time. Then she heard that Mr. Binglu, from Mr. Binglu is PW number 3, that the accused and the deceased had quarreled. And these are the specific things your lordship may note, which the prosecution is trying to project. Then PW2, this starts at page 74. He was a drinking partner of the group. In the oath, he says, I have been summoned as a witness in connection with the murder case of deceased Rakesh. I know the accused standing on the dock. He is my childhood friend. I was also arrested under suspect by police as I was present at Atobong Kola camp under Balokpung circle with the accused, deceased and other elders, namely Rakesh Beong, he is the victim, Rakesh Beong. Then Takeo Binglu, he is the PW3. Then Sunil Jebiso, he is PW6. At around 1 and 2 p.m., at around 1 or 2 p.m., Mr. Takeo Binglu and the deceased asked me to accompany them in the shade with alcohol in their hands. I agreed, and 3 of us reached Atobong and started drinking local wine. While 3 of us were drinking alcohol, once Sri Sunil Jebiso came and joined in the drinks. The deceased asked me to buy alcohol. The deceased asked me to buy alcohol, and accordingly, along with Sunil Jebiso, went to buy alcohol from the market. I have been to meet the deceased at the shop of Ajit Rangmo and asked him to join us. He told us that he was not matched with the deceased, and again I told him that it is up to him to join us or not. Later on, he came and joined us. On noticing the accused, the deceased lost his temper and started abusing the accused. The deceased stated that the accused is a non-tribal and that he would bury the accused before leaving Atobong. Anyway, the accused also joined with us in drinking alcohol even after the threatening from the deceased. The alcohol was completed and the deceased asked the accused to take money of rupees 120 to buy alcohol, and the accused came near to the deceased without clothes, only having a towel. The deceased first hold collar of the accused and slapped the accused thrice or 4 times without any reasons. On retaliation, accused gave 1 punch to the deceased. I asked the accused to leave the place, but Sri Binglu asked me to stay and slapped the accused twice. I separated them and cried. The deceased assured me that I would not be beaten. The accused was chased away by the deceased and the PO. However, the matter was compromised and the accused left the place in the evening when the dark started. The deceased, this is important, my lord, because there are, with the other witnesses, there are various contradictions on this point. The deceased and Binglu, that is the deceased and PW3, left the place after a gap of, according to him, the accused left the place first. Then after 5 or 10 minutes, deceased and Binglu also left the place after a gap of 5 to 10 minutes. I, along with Sunil Jebiso, that is PW6, left the place after 20 minutes time gapping. When the deceased and Binglu left, I, along with Sunil, came to the shop of the accused as to know the injuries sustained by him while he was not found, but he was not found in the shop. While I was having a cigarette at the shop of the accused, the PW1 told us that the deceased was found at the PO in injury state, and she stated she is going to inform the incident to the relatives of the deceased. The time gapping, the time gapping of the incident of leaving Atobong by the accused to information of PW1 about the injury of the deceased was hardly half an hour time. So that means if they left the Atobong at around 5 o'clock, then it would have been around maybe 5:30. I went to my home and did not visit the deceased. On the next day at 6 a.m., I was arrested by the police. The accused was arrested after 5 days of the incident as he was absconding, and I heard from the police that the deceased was killed by the accused. In the cross, he says, the accused is a normal person, as I know, but often lost his temper for joking by the friends. The accused sustained injury on that day and swelling on the face. The deceased was not liked by the people of the colony. He was very aggressive after consumption of alcohol and always used to show his down. When the accused left the place, it was lightly dark. When I got the information from the PW1, it was totally dark. I heard the deceased was having a case under NDPS Act. Then PW3, this is also the drinking partner, friend, Takio Binglu, page 76. I have been summoned as a witness in connection with the murder case of deceased Rakesh Beom. I know the accused standing on the dock. He is Sagar Sabor. I was also arrested under suspect by police as I evacuated the deceased by picking up the deceased near the house of PW1. I was also present at Atobong Kola Camp under Balukpung Circle with the accused, deceased, and others. Rakesh Beom, PW2, and Sunil Jebiso. The accused, the alcohol was finished at Atobong, and the accused was asked to buy alcohol by the deceased, to which the accused refused, and the deceased beaten the accused. The accused retaliated to the deceased. However, the matter was compromised. The accused, along with Sunil Jebiso, left the place Atobong. Your Lordship will recollect at PW2 has said that the accused left alone, and the PW2 along with Sunil Jebiso left the place. But here, this person is saying that the accused along with Sunil Jebiso, that is PW6, left the place, and after a few minutes, I along with the deceased left the place. Atobong, I went to my home, and the deceased also left for his house. Again, within an hour, some of us gathered at the construction site nearby the resident of PW1. It was become dark, and I do not recall the time. The deceased and the accused were not present in the gathering in the construction site. When the incident was informed by PW1, we rushed to the PO, and I dispersed with the deceased nearby my house in a juncture where the footpath is leading to the house of the deceased in the village. The normal time to reach the juncture from my house from Atobong is 5 to 6 minutes. The PO where the dead body of the deceased was found is 300 to 400 meters from the juncture of my home. The time from dispersing to Atobong by the accused to the information received from PW1 was 1 to 2 hours. The deceased was lying on the road in an injury state and blood oozing from the body. He was not able to speak. We evacuated him into hospital. I lost my slippers at PO while picking up the deceased. After a few minutes, we were informed that the deceased has expired at Hope Health Clinic, Balukpung. The police came later on and recorded our statement. We were detained in the custody in the same evening. I heard later that the deceased was killed by the accused while I was in custody. In the cross, he says, I know the accused long time. The distance between my house and the diversion is around 50 feet. Diversion road is 50 feet. The road leading to the house of the deceased is not an isolated place, but a village. The distance between the construction site where we were merrymaking is 20 feet away from the dead body of the deceased. The PW1 informed us from the PO, we did not hear any sound of incident, though it was near as we were playing guitars. It is true that my slippers were seized by the police. The deceased was good to me, but not good to other people after having alcohol. I heard that deceased was having a case under NDPS Act. I do not think the accused has committed the offense. The court puts a question, how long you stayed at home after dispersed from the deceased at diversion point? He says, I stayed around 1 hour in my home. Sri Arun Rai came to my home with a proposal to go to construction site to play guitar and sing. So according to him, after they left from Attabong, which was after the accused left, as per the statement of PW2, maybe 5-10 minutes after that, after a lapse of 1 hour, they came to the construction site for further merrymaking. Then, from then on, after some time, it was informed that the deceased was injured. This is not in conformity with the statement made by the PW2, who says that after they disperse, because it is around the same time that it is dispersed, almost around the same time, after 30 minutes, the information was received. I'm saying this because the learned trial court has discussed in a very lengthy manner what would be the time of the death, because it is not specific from the records. Then PW4, Lordship, is Vikas Mohilia. He was not present in the drinking party at Attabong, but later on, in the construction site, he was one of the members. May I read, Lordship? Page 78. I have been summoned as a witness in connection with the murder case of deceased Rakesh. In the evening time at construction site nearby the house of PW1, we were playing guitars and singing. Sri Firoj and Ali, Kumar, Toy, Arun and Takio Binglo were present. While we were entertaining, suddenly we heard the sound of a running of a person. We tried to look at the sound of running, but no one was seen. Again, we started our merrymaking. And after 20 to 25 minutes, the PW1 informed us about the incident. Accordingly, we came to the PO and found that this was lying with a belly on the road. When we turned his body, we found blood on his body. The deceased was evacuated medical by us. All other boys went back to their home to change clothes and came back to the hospital. I did not go back to my home. The doctor informed about the death of the deceased and told me not to tell the matter to other persons till arrival of the police. Police came and detained us for safety measures. I know the accused standing on the dock. He is Sagar. I also know the deceased. In cross, he says, I heard the deceased was having a case under NDPS Act. The accused is a normal person. I did not see the injury of the deceased as I was nervous on seeing the blood. Now, Lordship may recollect, PW3 says that since they were playing guitars, they did not hear any sound. But this PW4, in the same place, he says that we heard somebody running, but we did not see, but no one was seen. That some sounds were heard. So this is in total contradiction with each other. They do not support each other. Then PW5. PW5 is the shop owner who was one of the second last persons to see the deceased alive. Page 79. I have been summoned as a witness in connection with the murder case of the deceased. I know the person standing on the dock. He is Sagar since 2001. The accused was with me in my shop, and I know the incident from PW1. I was also detained in custody. The incident of quarreling between accused and deceased was told to me in the custody by my friends. The accused was absconding as he was suspected. On the day of the incident, the accused came back to the shop at around 5 to 5:30 p.m. and left the shop to meet his supervisor who came from Mumbai. Since then, he did not return in the evening. Later, he was arrested and detained with us. In the cross, he says, I do not know the reasons for quarreling between the deceased and accused and deceased. The accused is a normal person. I do not believe the accused had committed the offense. The deceased quarreled with some person with others and have criminal records. His statement was taken twice, although I'm not very sure why. It's 24th of July. The statement that I'm reading is on 24th of July 2019. Then the next statement was again taken on 4th of December 2019. In the cross, he says, in the out, he says, page 80, the rough sketch map drawn by the police showing my shop, PO, and house of the deceased are correct. It is correct that the deceased and the accused came to my shop in the evening on the date of the incident. The deceased came first before the accused to my shop to have a cigarette. Later on, the accused came to my shop after the deceased left my shop. There was a gaping of half an hour between the time of the deceased left my shop and arrival of the accused at my shop. The deceased took the footpath road to as shown in the rough sketch map. The accused left the road as shown in the rough sketch map. The accused stayed in my shop for around half an hour and had dinner with me. I do not remember the wearing appearance of the accused. The accused had surrendered himself before the Balokpung police. The accused was my friend and most of the time he stayed with me. At around 8 p.m. I heard the incident of the deceased. I did not go to the PO to pick up the dead body of the deceased to evacuate in hospital. I made a call to the accused while in custody as per the instruction of the police. As the call came, as the accused called me on my mobile, we had a discussion. I told him that the deceased was lying unconscious and on suspect, I was arrested. I told him that he is one of the suspect and I asked him to come to the PS to clear the matter. Accordingly, he came. The arrival of the deceased and the accused in that evening was between 5 to 6 p.m. Then in the cross, he says, my shop used to close by 7:30 or 8 p.m. The accused went upward towards the bridge, after which road he took, I do not know. At around 7:30, I heard about the incident of the deceased. I do not remember the person came to my shop in that evening. The other friends were present nearby the PO, but they did not heard about the incident. The accused came from Mumbai. It may be true that the accused should have run away if he had committed the offense. Then, my lord, PW6. PW6 is also one of the drinking partners in Atobong, the first part. Sunil Jebiso, page 82. I have been summoned as a witness in connection with the murder case of Rakesh. I know the accused by name. I was arrested under suspect by the police in this case. I was present at Pung near Balokpung Circle with the accused, deceased and other friends, namely Mintu, Takio Binglo, and one more person whom I forgot the name. We were consuming wine. We left the place before sunset. I left the place along with Mintu, that is PW2, and forgot the rest persons as I was drunk. On the next morning, I was arrested by the police. What happened in the evening on that day is not known to me. The police have recorded my statements. There was quarreling among friends at Pung area after consumption of alcohol, but I forgot who were the persons quarreling and who were pacifying. I was released on the same day of arrest. Accused and the deceased were my friends. I do not know why I have been arrested in the case and also who killed the deceased Rakesh. The defense had declined the cross. Then page 83, this is the doctor who had conducted a postmortem. I have been summoned as a witness as I have conducted PME of the deceased Rakesh and submitted the report. The case was of Balokpung PS under PME. Externally, I found multiple stab injuries on chest, neck, and back of the body of the deceased. I mentioned the age of injury, which was 12 to 24 hours at the time of PME. The injury was caused by a sharp weapon like a knife or dowel. The cause of death was hemorrhage, shock due to excessive bleeding. I got a requisition letter from the police to conduct a post-mortem of the disease. P Exhibit 1 is PME report, which I prepared. P Exhibit 1 is my signature. Then P Exhibit 1B is a signature of DMO, which I've identified. P Exhibit 2 is handing and taking over the body. P Exhibit 2A and B are my signatures. My findings are mentioned in the PM report. In the cross, he says, I have 17 years practice in the present profession. I do not remember exact number of the autopsy conducted by me in my service. The deceased was brought to me at around 9 a.m. I had discussion with the IO of the case before conducting PME. No police personnel were present at the time of examination of the PM. There were internal injuries on the left side of the lungs. The injuries found on the deceased cannot be sustained from falling above to ground, as there were multiple injuries in the body, which reveals that it was sustained from other person. In case of falling from above the ground, the injuries would be one-sided injury. Then PW8, Narayan Sharma, whose statement was heavily relied on by the learned trial court while convicting the accused. But Lordship, I may point out this PW8 Narayan Sharma was not, his statement was not recorded under 161. He came as a witness for the first time here, even though it is mentioned in the charge sheet about him, but for some reason his statement was not recorded under 161. Page 84, my lord. I have been summoned as a witness in connection to this case. I have a shop at Lower Balukpung, which I personally run the shop. I forgot the date, but it was evening around 7 to 7:30 while I was closing the shop. The accused appeared in the shop and purchased one Marigold biscuit, one cigarette. I have given statement to the police on the next day. It is not in the records, my lord, even though it's said like this. The police asked me about the boys visited my shop. I told the police that many boys used to visit my shop. Again, the police asked me to have seen the boys to have committed affray. Just then I remember that one boy whom I did not know came to my shop with blood on his right hand while receiving cigarette, which I noticed. The police asked me to come to police station, recorded my statement. The accused is standing on the dock. Accused standing on the dock was the person whom I had given the cigarette and noticed blood in his hand. My shop is located between Shiv Mandir and Namgarh. P Exhibit 3 is my shop in the rough sketch map. But in the cross, he says, I do not exactly remember the face of the boy who purchased cigarette Marigold in that evening. I am also not sure that the accused is standing on the dock is the boy who purchased the cigarette Marigold in that evening. Then, my lord, PW9. Is Prasanta Bora, 85. I have been summoned as a witness in connection to the murder. In the case of murder, I was not examined by the police. I heard the accused and had committed the murder. The police arrested Bikas, Mintu, Binglu, and Arun on the day when I was going to give food to my son, Mintu Bora. This is PW2. I noticed the accused standing in the middle of the road nearby Kolakem RCC bridge, Balukpung. The accused told me he was going to the police station and on the way at Checkgate, the police apprehended the accused. I also came to jail to give food to my son. My son was arrested in connection to the death of deceased Rakesh Beong, as he was in the party of the deceased. In the defense, he says, I know the accused since childhood. He was good in our views. Then PW10, he is the previous IO, page 86. I came to this court as a witness in connection to the case in capacity of the IO. I was posted at Balukpung at that point of time as CI on 19/2/2017. A complaint was received from Nyakum Ragmo alleging that in the evening around 8 p.m. Was found murder and complaint strongly suspected his friends Ajit Rangmo, Binglu Takyo, Arun Chetri, Sagar Adivasi, and Vikas Boro. Accordingly, the case was registered and endorsed me for investigation. I visited the PO, drawn sketch map and seized blood samples from the PO. Dead body of the deceased was sent to PME. I seized sporting T-shirt from of the deceased body. During the investigation, I came across a pawn shop keeper Balukpung who told me in the evening that the accused came to his shop asking for cigarette and or something else, during which he saw the blood on the face and clothes of the accused. Accordingly, my suspect to the accused became more strong and leading to arrest of the accused. The accused fled away to Assam. The accused was trapped by his friend Ajit Rangmo over mobile phone, saying the victim was alive and under medical treatment, and the accused was to provide necessary medical treatment as a result of the incident. Ajit Rangmo was in custody. As such, the accused came back to Balukpung on being trapped. The accused apprehended a check gate. Accordingly, I arrested him. During the investigation, he admitted to commit the offense. I identified the accused standing on the dock. According to the accused, during interrogation, he was proceeding towards his mother's house in Assam side and accidentally happened to meet the deceased on at PO, who was coming to join with the party of his friends. Party of his friends. The deceased attacked the accused first, and during the scuffle, a knife came to the hands of the accused and he stabbed the deceased. The accused had a motive, as the deceased humiliated him as and when they gathered. The accused had also committed theft from the hostel of surrendered Boro militants, as his long pant was smeared with blood. He was the sporting and thrown away the long pant in Assam side. I seized his sporting for FSL test. The weapon of offense could not be recovered. The other arrested persons who were found innocent and discharged after complete investigation. I charge sheeted the case under 302. I did not find any injury with the accused at the time of arrest. P Exhibit 4 is the rough sketch map of PO, and P Exhibit 4A is my signature. I can identify the the signature witness, Sri Vicky Beong. P Exhibit 5 is the seizure list of one slipper that belonged to one of the friends of the accused and the deceased, who evacuated the deceased for hospital. P Exhibit 6 is a seizure memo of red design sporting Genji and white half pant. P Exhibit 6A is my signature, and P Exhibit 6B is a signature of Ram Rajpat, which I identify. P Exhibit 7 is a seizure memo of blue jeans long pant, and P Exhibit 7A is my signature. I can identify the signatures of two witnesses, P Exhibit 7B and C. P Exhibit 7D is the signature of the accused, which I can identify. P Exhibit 8 is the statement of the alleged accused, and P Exhibit 8A is my signature on it. P Exhibit 2C is my signature on handing, taking over of the dead body from the medical. P Exhibit 9 is the handing, taking of the dead body of the by the police. P Exhibit 9A is my signature. Material Exhibit 1 is the photograph of the escape route of the deceased, and same was taken leading by the accused. Material Exhibit A1 is my signature. Material Exhibit 2 is the Pan Gumti shop. Material Exhibit 2A is my signature. Material Exhibit 3 and 4 is the PO of committing a theft of pen by the accused. Material Exhibit 3A and 4A are my signatures. Material Exhibit 5 and 6 are picnic spot. Material Exhibit 5A and 5A and 6A are my signatures. Material Exhibit 7 to 9 is the photograph of the PO. Material Exhibit 7A to 9A are my signatures. I took the photograph from my mobile. Material Exhibit 10 to 20 are photograph of the deceased, and Material Exhibit 10A and 20A are my signatures. The statement of the accused was not recorded by the magistrate. P Exhibit 10 is the accused challan. P Exhibit 10A is my signature. P Exhibit 11 is forwarding of FIR, and P Exhibit 11.1 is my signature. In the cross, he says, I do not know the accused and the deceased were good friends. I have no idea about sending of FSL test to the seas sporting by the later IO. No eyewitness of the incident. I have not found any other criminal case of the accused during investigation. So far as I remember, that deceased was having a case to have been involved in NDPS case. It may be true that P Exhibit 5 slipper belongs to Ajit Rangmo, who was one of the persons who had evacuated the deceased. Now, Ajit Rangmo is the PW5. In his statement, he has said that he did not go to evacuate. He was there in his shop till 7:30. This is in total contradiction. From where this is taken, we don't know. The accused told me that the weapon of offense was thrown in Sunday market, and next day was Sunday market. I have not enclosed, this is important, Lordship, I have not enclosed the authenticity certificate of all material exhibits. Material exhibits are the photographs. I have not mentioned the date and time in all material exhibits. Not received any FIR for stolen of pen. Civilians were also present at the time of seizing of materials. It is not a fact that I have forcefully recorded his admission statement. I have not found any other enemies of the deceased during investigation, except the accused had no good terms with the deceased, and the deceased always humiliate the accused all the time, as and when they happen to meet each other. It is not a fact that the accused would have returned to Balukpung, as he would not have returned to Balukpung, as he did not commit the offense. The accused had good terms with Ajit Rangmo. The accused did not meet Ajit Rangmo after the incident. Then PW 11 is a seizure witness. He has this Lordship, he says that I accompanied with the IO of the case during investigation and witnessed the seizure of T-shirt of the accused at PS after arrest from his position. I know Mr. Sagar Sabur. I know the accused, Mr. Sagar Sabur, after arrest him. I have not seen anything in the T-shirt. He's probably referring to blood stains and all. It was seized in connection with the murder case. P Exhibit 12A is my signature. Then in the defense, the cross, he says, it is not a fact that I have put my signature. It is not a fact that I have put my signature involuntarily. Then PW 12, he is the informant. Page 90. He is the informant and also the brother-in-law of the deceased. PW 12, page 90. I am connected to the witness of murder of my brother-in-law Rakesh Beong. Incident occurred on 2 to 3 years back. I can identify the person standing on the dock. He admitted before me to kill the deceased. I strongly suspect that some other persons are also involved in the offense. Ajit Rangmo, Vikas Boro, Takio Binglo, Arun Chetri were together with the deceased. As such, I have doubted the whole day the deceased was in the aforesaid portion with the aforesaid person, including the accused. On the day of the incident, the deceased got payment from All Metal Company, Kimi. I got information of the incident from Nachung Takio. I came to the private hospital located at Lower Balukpung. I saw the deceased body and found cut injury in the left portion of the chest and neck. The deceased was sent for PME. I lodged a FIR at Balukpung PS on search of the deceased body. An amount of rupees 3,000 was found. I have no idea about enmity with the deceased. The accused was arrested after 5 days of the incident. P Exhibit 13 is the FIR. P Exhibit 13A is my signature. In the cross, he says, I heard that the deceased and all suspected persons, including the accused, together nearby the PO that night. It may also happen that some other suspected accused may have committed the offense with the accused, but the accused is not telling us the truth. The deceased was arrested for other offense. The deceased was getting around 8,000 to 9,000 per month as security guard. The deceased was also sustained stab injuries on the neck and chest. I heard other suspected persons were set at liberty as the accused had claimed to commit the offense alone. Then PW 13. This is, as per the prosecution story, the last person maybe to have seen the accused, deceased alive. This is the sister of the accused person, Ragami Rangmo. She says, I'm connected to the case as witness of murder of my brother Rakesh Beong. I saw the accused along with other friends with the deceased on the day of the incident. At 5 p.m., my brother came to my house at Kola Kem, Balukpong, alone and had dinner. His house is also nearby my house. He left around 30 minutes from my house. So it must have been around 5:30. While I was cleaning the potatoes in the evening, Srimati Rangmo shouted and telling us that my brother got cut injuries lying dead in the road. The incident report from Rina Rangmo came about half an hour from the time of leaving my house. Immediately, I rushed to the PO and found the deceased was evacuated to the hospital by his friends. Well, when I was at the hospital, Mr. Ajit Rangmo told me that the deceased visited his shop while coming back from my house and asked for cigarettes and matches by paying a sum of ₹2 only. On the day of the incident, the deceased got a payment of ₹2,000 was handed over to me by police, which was recovered from the deceased. I told all the friends of the deceased who were together with the deceased on the day of the incident. All persons' names were arrested except Sagar Sabar, who was absconding. As he was absconding, accused was staying with Ajit Rangmo. A few days, someone had seen accused coming from the house of Ajit Rangmo and going towards the PS. When I reached the accused, asked him why he had killed my brother. The accused told me that he would speak the truth before the police and he is innocent. In the meantime, police arrived and took him away. I heard the accused admitted his guilt before the police. My husband and mother went to the police and heard his admission. I do not know the reasons. For behind the killing. Police have recorded my statement. I saw 2 stab injuries on the ribs side of chest, 1 stab injury neck side, and also on the chin. After 1 month of the incident, one of my cousin brothers, Sri Ajit Rangmo, Mr. Dayuk Gyadi, 1 month after the incident, one of the cousin brother of Ajit Rangmo, he's PW5, Ajit Rangmo, Mr. Dayuk Gyadi, aged about 5 years, stated in the presence of many other persons in our colony that the deceased was actually killed by Ajit Rangmo. I also heard the weapon of offense was recovered from the house of Ajit Rangmo and slipper of Ajit Rangmo was found at the PO. I never believed that the accused could kill my brother as he was physically weak compared to my brother. I believe that the accused might have committed the offense with some other persons, but he cannot do it alone. Then in the cross by defense, he says, Rina Rangmo informed me around 5:30. She came to know about the incident on listening, I think it should be listening, a sound, and came out to see it. She found the deceased was lying on the road. The PO is a silent place. Ajit Rangmo and accused were not present in the PO. It is true that the deceased was having a criminal case. He might have enemies. It may also be possible that the deceased is confessing the guilt on behalf of others. Then
It's Rina Rangmo, Rina Rai.
Regina Rangmo is different. Rina Rai is different. Rina Rai is, yes.
The Rina Rai, Rina Rangmo, same person.
No, different.
Rina,
Different.
Different, yes. Rangmo is the sister and Rai is the PW1, my lord, who has passed in
No, it says that Rina Rangmo informed me at 5:30 p.m. in the last paragraph.
yes. We don't know who this Rina Rangmo is because she's
Rina
not,
Rai is PW1.
Rina Rai is
Yes.
PW1.
Rina Rai is PW1.
Rangmo's name is not there anyway.
No. Rangmo's name is not there. Rina Rai.
Ragami Rangmo, my lord.
Ragami is the
Ragami is the
sister.
No,
brother,
that is sister.
sister,
understood.
yes.
That is understood.
Perhaps, my lord.
I'm just.
The surname has been wrongly inserted, madam. The Rangmo one.
Please.
Because The deceased was found near the house of Rina Rai. And she says that,
That is why
yes.
this court is asking
yes,
whether this is the same person, because she was told that Rina.
there is no mention of Rina Rangmo except for this.
Correct.
Then this is Anand Topno, the
Yes.
PW14. He says, I know the case. It is related to murder case of Rakesh. I have not seen the incident, but I heard that the accused Sagar Sabor had committed the offense. After 2 months, I was arrested by the police in connection to this case. I do not know the accused standing on the dock. The incident took place in the evening time at around 6 p.m. on 18/2/2017. I was at Kola Camp at that time in the house of sister-in-law. I heard the sound of shouting of people, and I came out after the house and noticed that the deceased was lying on the ground on bloodshed. The PO is nearby the house of my sister-in-law. I, Vikas, and other friends evacuated Rakesh to Hope Clinic. After that, I came home and changed my clothes because blood stains were on my clothes, and accordingly, police called me to reach Hope Clinic, and accordingly, I've been arrested. He is only saying that he came to know after the incident. Then I did not, in the cross, he says, I did not know the name of the deceased before incident. I know him by face. At the time of arrival at PO, the deceased made sound like sound of a dog. He could not speak. The PO was not much visible as there was no light. I have not seen any person escape from the PO. He was also in that after party in that construction site. I have not seen any person escape from the PO. I, along with some other persons, were arrested by the police on suspect by the relatives of the deceased. Then page 94 is the second IO, Duto Bagra. I have connected to this court as I am second IO of the case. This case was endorsed to me on 8/9/2017. I have examined 1 or 2 witnesses. I have prepared reconstructed sketch map. I filed charge sheet under section 302 on the basis of investigation already done by previous IO. The motive of the crime was for revenge. The accused and deceased were friends, but on the day, accused Sagar Sabar, Sunil Jabiso, Mintu Bora, Takio Binglu, and deceased had gone to picnic at Atotung, Atopung is written, located in Kola Camp, Walokpung. They consume alcohol and ganja at picnic. The local beers which they have brought were finished, but they wanted more. Mr. Mintu Bora was asked to fetch more beer by the deceased, but Mintu Bora handed over the money to the accused Sagar Sabar to fetch local beer, but the accused refused. On refusal by the accused, deceased Rakesh Beong got annoyed and slapped the accused. After having fun at Atopung, they left for their house, own house in the evening. In between 6 to 7 p.m., the accused came to the shop of Ajit Rangmo. At the same time, the deceased also came to the shop, and after purchasing the cigarette, deceased left for his home. As soon as the deceased left for his house, accused also left, telling Ajit Rangmo that he was going to visit his mother. Both of them left in different directions. There are 2 roads leading to the house of the deceased. One of the roads is towards left, other is towards the right of the shop of Ajit Rangmo. Deceased took the left direction and accused took the right direction. Instead of visiting his mother, accused turned towards the road which lead to the house of the deceased. On the way, he found deceased and assaulted him with knife, due to which deceased sustained multiple injuries and succumbed to his injuries. The deceased disclosed the accused disclosed that after committing crime, he took the road to Sunday Market located under Assam and came onto the highway, where he went to a shop run by Mr. Narayan Sharma. At that time, there were bloodstains on his face, hands, face, body, and clothes. He asked for biscuit and cigarette from the shopkeeper. When the shopkeeper queried him about the blood on clothes and face, the accused told him he had a fight with a boy. After that, alleged accused proceeded towards Thursday on foot and had stolen jeans pant from the house of Rahul Nursery. After that, he went to the bank of river of Kameng and washed himself. The weapon of offense could not be recovered as it was thrown in Sunday Market, and immediately next day Sunday Market was conducted there. P Exhibit 14 is charge sheet. P exhibit 14A and B are my signature. P exhibit 15 is a seizure list. P exhibit 15A is my signature. P exhibit 16 is a particular of the accused. P exhibit 16A to H are my signatures. P exhibit 17 is a particular of witnesses. P exhibit 17A is my signature. P exhibit 3 is reconstruction of the rough sketch map of the scene of crime. P exhibit 3A is my signature. P exhibit 18 is a statement of Ajit Rangmo, and P exhibit 18A is my signature. P exhibit 19 the statement of Prasant Borua. P exhibit 19A is my signature. P exhibit 20 is a statement of Narayan Sharma. P exhibit 20A is my signature. In the cross, he says, after 7 months, I have prepared the sketch map of PO. It is revenge case as disclosed by the accused that the deceased used to humiliate him as and when they meet each other. I have not found criminal background of deceased during investigation. I do not have any idea about the habitual offense of the deceased. It is not a fact that there was no sufficient strong evidence against the accused, though there were no eyewitness of the incident. Then PW 16 is also a seizure witness, page 96. He says that he is a witness to the seizure P exhibit 5 and 5B. Then P exhibit, PW 17, page 97, he is also a seizure witness. But interestingly, he says that he had witnessed the recording of the statement of accused by the police in which the accused was admitted to have committed the crime. He's a seizure witness. Page 97. Police called me in IO, but I have not put my signature on seizure memo P exhibit 5. The signature appears corresponding to my name at P exhibit number 5 is not belong to me. He denies having been a seizure witness in P exhibit 5. Then he says, I have present at the time of recording of the accused by the police during which the accused admitted to have committed the offense. Then in the cross, he says, I did not give statement to the police. Then the accused also presented himself as defense witness. Page 98. He says, I'm appearing as a defense witness in my own case. Admittedly, I was present in the party in daytime, but I was not present at the PO at the time of incident as I was in other place. At the time of incident, I was at Chardwar. The party ended around 5 p.m. and I came back to my partnership shop with Ajit Rangmo. From the shop, I went to the house around 5:40, then to a bus stand around 6 p.m. I was called from Chowdhury by Ajit Rangmo over telephone, informing that deceased was beaten by unknown person and asked me to come back if I have not committed the offense by the deceased. He also told me that the deceased was in medical, alive and unable to speak. Accordingly, I came back to Bhalukpur and told him that I have not committed the offense. I would not have returned if I had committed the offense. In the cross by PP, he says, it is not a fact that I would never come back if I heard the news of death of deceased. I received the call after 4 days of the incident. It is not a fact that I made a call to Ajit Rangmo in order to gather information about the deceased. It is also not fact that my hand was spotted of blood at the time of purchasing cigarette from shop. It is a fact that deceased used to humiliate me at various occasions. He was aggressive in nature. I informed my mother and sister about going to Chardwar. I do not know about the exact incident. I am unable to produce other defense witness. Court asked him a question saying, in the court examination, he says, my home is walking distance of 15 minutes from my partnership shop with Ajit Rangmo. The distance between the shop of Ajit Rangmo and Narayan Sharma is will be around 25 minutes. The above statement is recorded. Then Lordship is the judgment. Now, Lordship, from the judgment, it appears, number one, there was a long discussion on the time of the incident.
Ms. Duncan,
Yes,
can you first take us to 313?
sorry. Lordship. 313 starts at page 62. Question number 1. PW1 Srimati Reena Rao deposed that the deceased was her neighbor. She heard a sound like vomiting of a dog. She came out from the house, noticed a person lying on the road. She came close to the person and identified the deceased Rakesh. She called Binglu by name, who was present in a house nearby the PO. He came along with other boys and found blood on the body of the deceased. The boys evacuated the victim to the hospital. The deceased was not in a state of speaking. She informed the relatives of the deceased was alive till he was evacuated to the hospital. It was evening time, but she cannot exactly say the same. After the death of the deceased, police arrived in the hospital and recorded their statement. She had stated same thing, whatever she had deposed. Police arrested all the boys who evacuated the deceased to the hospital and also her husband. Her husband was also with the boys who were present near the PO and busy in merrymaking. She recognized you on the dock. She knew you long time back. You were under suspected to commit the offense as you had quarreled with the deceased on the day of the incident after consumption of alcohol. Later on, you were arrested by the police. Do you have anything to say? His answer is, it is not a fact that I am known to PW1. It is a fact that I am known to PW1. It is also a fact that I had quarreled with deceased on the same day of the incident around 4 p.m. However, the quarrel was totally compromised amongst us. After quarrel, we disposed from Chariali. The deceased and Binglu went together. I came to the shop, which was opened by me and Ajit on partnership. I left the shop to my own house as there was a call from my supervisor from Mumbai with instruction to manage labor. After that, I did not meet the deceased in the evening and night. Next day, I was at Rangia. I came to Balukpung as I was called by Ajit Rangmo informing Rakesh was in serious condition after quarrel. I did not admit to commit the offense before police. The police tortured me to admit the offense. Then question number 2. PW2, Mr. Mintu Borua deposed that you were his childhood friend. He was arrested under suspect by police as he was also present at Attabong, Kolakem. Under Balupong circle with you, deceased and other elders, namely Rakesh Beong, Takio, and Sunil Jabiso. At around 1 to 2 p.m., Mr. Takio Binglu and deceased asked him to accompany in the shade with alcohol in their hands. He agreed, and 3 of them reached Attabong and started drinking local wine. While 3 of them were drinking alcohol, Sunil Jabiso came and joined in the drinks. The deceased asked him to buy alcohol, and accordingly, he, along with Sunil Jabiso, went to buy alcohol from the market. He had been to meet you in the shop. He had been to meet you in the shop of Ajit Rangmo and asked you to join him. You told that you were not matched with the deceased, and again you told it is up to you to join them or not. Later on, you came and joined them. On noticing the deceased lost his temper and started abusing you. And the deceased stated that you are a non-tribal and he would bury you before leaving Attabong. Anyway, you also joined with them in drinking alcohol even after threatening from the deceased. The alcohol was completed and the accused asked you to take money of rupees 120 to buy alcohol, and you came near the deceased without clothes, only having towel. This is first hold collar of you and slapped you thrice or 4 times without any reason. On retaliation, you gave 1 punch. PW2 asked you to leave the place, but Sri Binglu asked you to stay and slapped you twice. PW2 separated them and cried. This is assured PW2 that PW2 would not be beaten. You were chased by the deceased at PO. However, the matter was compromised. You left in the evening time when the dark started. The deceased and the Binglu left the place after a gaping of 5-10 minutes. He, along with Sunil Jabiso, left the place after 20 minutes gaping. When the deceased and Binglu left, he, along with Sunil, came to the shop of you to know the injuries sustained by him, but you were not found in the shop. PW2 was having cigarette in the shop. PW1 told them the accused was found in the PO, the deceased was found in the PO in injury state, and also she stated that she is going to inform the incident to the relatives, the time of gaping of leaving Atobong by you to information of PW1 about injury of the deceased was hardly half an hour time. You were arrested after 5 days of incident as you were absconding, and he heard from police that the deceased was killed. Why do you have anything to say? His answer is, it is true that PW2 is my childhood friend. It is fact that he, along with Rakesh Beong, Takeo Binglu, Sunil Jebiso, and I was present at Atobong Kola Camp on the day of the incident. It is a fact that Sunil Jebiso and PW2 asked me to join them in the party. I do not remember if I stated that I was not matched with the deceased for certain reasons. However, I joined the party as requested by PW2 and Sunil Jebiso. It is a fact that on noticing me, the deceased lost his temper and started abusing me. The deceased stated that I am a non-tribal and he would bury me before leaving Atobong. It is a fact that after the alcohol was completed, the deceased asked me to take a money of rupees 120 to buy alcohol, and I came near the deceased without clothes, only having a towel. The deceased first hold a collar of me and slept, I think it's typing mistake, slept you thrice or four without any reasons. It is a fact that I punched the deceased in retaliation. However, the matter was compromised and I left the place in the evening time when the dark was started firstly. It is not a fact that I was absconding from the police.
So the deceased was only having a towel.
In some, it is mentioned that deceased was having on a towel. I came near the deceased without clothes, near to the deceased without clothes, only having a towel.
So
It's not clear who was having the towel, who was without clothes, because it is also stated that the deceased had caught hold of the collar of the accused. But here, it is stated here that that I came near the deceased without clothes, only having a towel.
then again he caught hold of the collar.
Yes,
Whose collar?
that was also my,
Collar of the accused.
according to the statement, collar of the accused.
We'll do one thing. We'll
Yes.
take 5 minutes break and come back.
Right.
Madam? Yes, we were
We were on Mintu Bora.
64.
Yes, page 64.
Yes, you may-
PW3,
Hmm.
Mr. Takeo Binglu deposed that he knew you. He was arrested under suspect by the police as he evacuated the deceased by picking up the deceased nearby the house of PW1. He was also present at Atobong Kola Camp under Balukpong Circle with you. Deceased and other elders, namely Rakesh Beong, PW2 and Sunil Jebiso. The alcohol was finished at Atobong and you were asked to go to buy alcohol by the deceased, to which you refused, and the deceased beaten you. You also retaliated to the deceased. However, the matter was compromised. You, along with Sunil Jebiso, left the place at Atobong. After a few minutes later, he, along with the deceased, left the place at Atobong. He went to his home, and the deceased also left for his house. Again, within an hour, some of us gathered at construction site near the residence of PW. One, it was become dark, and he did not recall the time. The deceased and you were not present at the gathering at the construction site. When the incident was informed by PW1, they rushed to the PO. He dispersed with the deceased nearby his house at juncture where the footpath road is leading to the house of the deceased in the village. The normal time to reach the juncture of his house at Atobong is of 5 to 6 minutes. The PO where the dead body of the deceased was found is 300 to 400 meters away from the juncture of his home. The time of dispersing at Atobong by you to the information received from PW1 was 1 to 2 hours. The deceased was lying on the road in injury state, and blood was oozing out from the body. He was not able to speak. They evacuated him to hospital. He lost his slippers at PO while picking up the deceased. After a few minutes, they were informed that the deceased was expired at Hope Health Clinic, Balukpong. The police came later on, recorded their statement. They were detained in the custody in the same evening. He heard later on that the deceased was killed by you while he was in custody. Do you have anything to say? His answer is the statement of PW3 are correct up to the disperse and compromise of the quarrel, except the statement of retaliation to the deceased by me and leaving the Atobong along with Sunil Jebiso. In fact, I left alone the place. I have no knowledge as regards to the gathering of my friends near the construction house at PW1 in the evening. I have nothing to pass any comments on the statement of PW1 after disperse from the juncture. Then PW4, the next question, PW4, because Mohilia deposed that in the evening at the construction site nearby the house of PW1, they were playing guitars and singing. Sri Firoj, Ali, Kumar, Toy, Arun, and Takio Binglu were present. While they were entertaining, suddenly they heard a sound of running of a person. They tried to look at the sound of running, but no one was seen. Again, they started their merrymaking, and after 20 to 25 minutes, the PW1 informed them about the incident. Accordingly, they came to PO and found the deceased was lying with a belly on the ground. When they turned his body, they found blood on his body. The deceased was evacuated medical by them. All other boys went back to their home to change the clothes and came back to the hospital. PW4 did not go back to his house. The doctor informed him about the death of the deceased and told him not to tell the matter to other persons till the arrival of the police. Police came and detained them for safety measures. He knew you. Do you have anything to say? His answer is, I know PW4. I have nothing to pass any comments upon the statement of PW4. Then question number 5. PW5, Mr. Ajit Rangmo deposed, he knew you, Sagar, since 2001. You were with him in his shop. He knew the incident from PW1. He was also detained in custody. The incident of quarreling between you and the deceased was told to him in custody by his friends. You were absconding, as such he was suspected. On the day of the incident, you came back to the shop at around 5 to 5:30 p.m. and left the shop to meet your supervisor who came from Mumbai. Since then, you did not return in the evening. Later on, you were arrested and detained with them. It is correct that the deceased and you came to his shop in the evening on the date of the incident. The deceased came first before you at PW shop to have cigarette. Later on, you came to his shop after the deceased left PW shop. There was a gaping of half an hour between the time of the deceased left his shop and arrival of you at PW5 shop. The deceased took the footpath road 2 as shown in the rough sketch map. You left the road. Road 1 as shown in the rough sketch map. You stayed with PW5 shop for half an hour and had dinner with PW5. PW5 did not remember the wearing appearance of you. You had surrendered himself before the Balukpong police. You were PW5 friend, and most of the time you stay with PW5. At around 8 p.m., PW5 heard about the incident of deceased. I did not go to PO to pick up the dead body of the deceased to evacuate in hospital. PW5 made a call to you. Well, PW5 made a call to you while you were well in the custody as per the instruction of the police, as you called PW5 on his mobile. You had a discussion on the case. PW5 you told PW5 that the deceased was lying unconscious and on suspect. PW5 was arrested. PW5 told you that you were one of the suspect persons. PW5 asked you to come to PS to clear the matter. Accordingly, you came. The arrival of the deceased and you in PW5 shop in that evening was between 5 to 6 p.m. Do you have anything to say? His answer is, I'm not aware if deceased came to the shop of PW5 before I arrived here. I do not know the time difference of arrival of the deceased and me in the shop of PW5. It is a fact that there are 2 ways from the shop of PW5. One is leading to footpath and other is leading to railway station. It is true that I took the road leading to rail station. It is true that he made a call on my phone on 2 occasions and stated that deceased was in an unconscious state. It is true that he told me I'm one of suspect and asked me to appear at PS to clear the matter. Then 6, PW6, Sri Sunil Jebiso deposed that he knew you by name. He was arrested under suspect by the police in the case. He was also present at Pung under Balukpung circle with you, deceased, and other friends, namely Mintu Takio Binglo and one more person whom he forgot the name. They were consuming wine. They left the said place before sunset. He left the place along with Mintu and forgot the rest of the persons as he was drunk. On next morning, he was arrested by the police. What happened in the evening on that day is not known to him. The police recorded his statement. There was a quarrel among friends at Pung area after consumption of alcohol, but he forgot who were the persons quarreling and who were pacifying. He was released on the same day of the arrest. You and the deceased were his friends. He did not know why he had been arrested in the case and also who killed the deceased. Do you have anything to say? His answer is, it may be true that he, along with Mintu Bora, left the PO before sunset, but both of them was there while I was leaving the first PO. Then PW7, Dr. Tage Neha deposed that he had conducted PME of deceased Rakesh Beong and submitted the report. The case of Balukpung PS, during PME, externally he found stab injuries on the chest, neck, and back of the body of the deceased. He mentioned the age of injury in the report, which was 12 to 24 hours at the time of PME. The injury was caused by sharp weapon like knife or dao. The cause of that was hemorrhage shock due to excessive bleeding. He got the requisition letter from the police to conduct post-mortem of the deceased. Do you have anything to say? He says, no comments. I have nothing to pass any comments upon statement of PW7. Then PW8. PW8 Sri Narayan Sharma deposed that he had a shop at Lower Balukpung which he personally ran. He forgot the date, but it was one evening around 7 to 7:30 p.m. while he was closing the shop. You appeared in the shop and purchased one marigold biscuit, one cigarette. He had given a statement to the police on the next day. The police asked him about the boys who visited his shop. He told the police that many boys used to visit his shop. After the police asked him to have seen any boys to have committed a fray, just then he remembered that one boy whom he did not know came to the shop with blood in his right hand while receiving the cigarette, which he noticed. Then the police asked him to come to police station and record his statement. You were the person whom he had given cigarette and noticed blood in your hand. The shop is located between Shiv Mandir and Namgarh. Do you have anything to say? His answer is, it is true that I went to the shop of PWA to purchase marigold biscuit and cigarette, but the time was around 6 p.m. and not 7 to 7:30 p.m. I have no comments on the statement of PW8 after about noticing blood on my right hand at the time of delivery cigarette at the alleged incident of evening. Then PW9 Prasant Borua deposed that you told him that you were going to police station and on the way to check gate, the police apprehended you. His son was arrested in connection with the death of Rakesh Beong as he was in the party of the deceased. Do you have anything to say? His answer is, it is a fact that I happen to have PW9 near my shop, but not at Kola Cambridge. He told me about the death of the deceased. Then PW10, Sri Iga at the deposed that on 19/12/2017, a complaint was received from Nyakom Ragmo alleging that in the evening of 18/2/2017, around 8 p.m. was found murder, and complaint was strongly suspected your friends Ajit Rangmo, Binglu Takyo, Arun Chetri, and Vikas Bora. Accordingly, case was registered and endorsed him for investigation. He visited the PO, drawn the sketch map, and seized blood samples from the PO. Dead body of the deceased was sent to PME. He seized sporting t-shirt from the deceased. During investigation, he came across a shopkeeper. He came across a pan shopkeeper, Balok Pung, who told him in the evening, you came to the shop asking for cigarette or something else, during which he saw blood on face and clothes of you. Accordingly, his suspect to you have become more strong and leading arrest of you. You fled away to Assam. You were trapped by his friend by his friend Ajit Rangmo over mobile, saying that victim was alive and under medical treatment, and you were to provide necessary medical treatment. And as a result of the incident, Ajit Rangmo was in custody. As such, you came back to Balukpung from Assam on being trapped. You were apprehended at check gate, and accordingly, he arrested you. During an interrogation, you admitted to commit the offense. According to you, during interrogation, you were proceeding towards your mother's house in Assam side and accidentally happened to meet the deceased at PO, who was coming to the party of his friends. The deceased attacked you first, and during the scuffle, a knife came in the hands of you and you stabbed the deceased. You had a motive as the deceased humiliated you, and when they gathered, you had also committed theft from the hostel of surrendered Boro militants. As his long pen was smeared with blood, you washed the sporting, thrown away the long pen in Kameng River in Assam side. You seized his sporting for FSL test. The weapon of offense could not be recovered. The other arrested accused persons were found innocent and have discharged after complete the investigation and charged sheet under section 302 IPC. Do you have anything to say? His answer is all investigations and statement recorded by PW10 are admitted by me under torture. Then PW11 Pasang Dorji deposed that I accompanied with the IO of the case during investigation, witnessed the seizure of T-shirt of you at PS after arrest from his position. Do you have anything to say? He says, it is true that my T-shirt was seized from me. Then PW12 Nyakam Rangmo deposed that that incident occurred on 2 to 3 years back. He can identify you standing on the dock. You admitted before him to kill the deceased. He strongly suspects that some other persons also involved in the offense. Sri Ajit Rangmo, Vikas Boro, Takya Binglu, Arun Chetri were together with the deceased. As such, he had doubted whole day the deceased was with the aforesaid person, including you. On the day of the incident, the deceased got payment from All Metal Company, Kimi. He got information of the incident from Nachung Takyo. He came to the private hospital located in Lower Balukpung. He saw the deceased and found cut Gami Ragmo deposed that she saw you along with other friends at the deceased on the date of the incident. At 5 p.m., her brother came to her house at Kolakem, Balukpung, alone and had dinner. His house is also nearby. He left around 5:30. He left around 30 minutes from her house while cleaning potatoes in the evening. Srimati Rina Rangmo, again here. Rina Rangmo shouted and telling them that her brother got cut injuries lying dead on the road. The incident report from Rina Rangmo came half an hour from that time of leaving her house by the deceased. Immediately, she rushed to the PO and found the deceased was evacuated to the hospital by his friends. When she was at the hospital, Rina Rangmo told her that the deceased visited his shop while coming back from her house and asked for cigarettes and matches by paying a sum of ₹2 only. On the day of the incident, the deceased got a payment of ₹2,000 was handed over to her by police, which was recovered from the deceased. She told all the friends of the deceased who were together with the deceased on the day of the incident. All named were arrested except you, as you were absconding. You were staying with Ajit Rangmo. After a few days, someone had seen you coming from the house of Ajit Rangmo and going towards the PS. When she reached you, asked him why you killed her brother. You told her that he would speak the truth before the police and he's innocent. In the meantime, police arrived and took him away. She heard that you admitted to the guilt before the police. Her husband and mother went to the PS and heard your admission. She did not know the reasons behind the killing. Police have recorded her statement. She saw 2 stab injuries on ribs, side of chest, 1 stab injury, neck side, and also on chin. Do you have anything to say? His answer is, I do not know the PW13, but it is a fact that my deceased and my friends and the deceased were together on the day of the incident. I do not know if the deceased had dinner at 5 p.m. in the house of PW13 and left her house. I have nothing to pass any comments upon the statement of PW13. And then PW15, Duto Bagradi posted this case was endorsed to him in 18/9/2017. He had examined 1 or 2 witnesses. He also prepared reconstructed rough sketch map. He had filed charge sheet under section 302 on the basis of investigation already done by the previous IO. The motive of crime was for revenge. You and this were friends, but on that day, you, Sagar Sabor, Sunil Jibiso, Mintu Borwa, Takio Binglu and deceased had gone to picnic at Atofung, located in Kolakem, Bolokpung. You consume alcohol and ganja at picnic. The local beers which you brought were finished, but you wanted more. Mr. Mintu Borwa was asked to fetch beer by the deceased, but Mintu Borwa handed over the money to you to fetch local beer, but you refused. On refusal, Deceased Rakesh Byong got annoyed and slapped you. After having fun at Atofong, they left for their own house in the evening. In between 6 to 7 p.m., you came to the shop of Ajit Rangmo, and at the same time, the deceased also came to the shop. After purchasing a cigarette, the deceased left for his home. As soon as the deceased left for his house, you also left, telling Ajit Rangmo that he was going to visit his mother. Both of them were in different direction. There are 2 roads leading to the house of the deceased. One of the roads is towards the left and another is right on top of the shop of Ajit Rangmo. Deceased took the left direction and you took the right direction. Instead of visiting his mother, you turned towards the road which leads to the house of the deceased. On the way, you found deceased and assaulted him with a knife, due to which deceased sustained multiple stab injuries and succumbed to his injuries. You disclosed that after committing crime, you took the road to Sunday Market located at Assam and came on the highway before you went to the shop run by one Mr. Narayan Sharma. At the same time, there were blood stains on your face, on your hand, face, body, and clothes. You asked biscuit and cigarette from shopkeeper. When the shopkeeper queried you about the blood on clothes and face, you told that you had a fight with a boy. After that, you proceeded toward Thursday on foot and had stolen a jeans pant from the house of Rahul Nursery. After that, you went to the bank of Kameng River and washed yourself. The weapon of offense could not be recovered. It was thrown in at Sunday Marketplace, and immediately next day Sunday Market was conducted. Do you have anything to say? He says, it is not a fact that I have admitted before PW15 that I have committed offense as revenge, as the deceased used to humiliate me. Then PW16 and 17 have deposed that they have witnessed exhibit. Do you have anything to say? He says, I have nothing to pass any comments upon the statement of PW16 and 17. Then, as you have admitted to visit the shop of PW5 Ajit Rangmo, can you tell this court that what time you left the shop of PW5? He says, I do not remember the time of my arrival at the shop of PW5. Then the question, another question is, as you have admitted to visit the shop of PW8 around 6 p.m., can you tell this court that where you have been after you left the shop of PW5 before reaching the shop of PW8? He says, after I left the shop of PW5, I went to Chardwar to meet the labor by hired vehicle. I do not know the person of hired vehicle. The distance between the shop of PW5 and Chardwar is 30 km. After that, I never came back to Balukpung, and I left for Rangia along with labor. I cannot remember where have spent the time half an hour after I left the shop of PW5 before reaching the shop of PW8. Do you have any defense witness? He says yes. So this is the 313. As your lordship might have noticed. Yes, he himself. Your lordship must have noticed that there are certain things which he had done against himself in the 313 with regard to the question of PW8. Narayan Sharma. That is the only thing there. Others, they're not necessarily against him. Now, Lordship, on the basis of this, the judgment that we are challenging was passed. Judgment starts at page 99. This is date of the judgment and order is 30/4/2021. He was sentenced to life imprisonment under section 302. I am not going to read the whole judgment, but the analysis of the evidence which the court had done, that starts at page 45 of the judgment. In the paper book, it's page 143. It is a summary of the page 143 is a summarized findings as drawn. Then evaluation actually of the evidence and findings for decision at page 133. The Lordship may see 133 first. One 134 is regarding the provisions of 302, 135 also. Then 136 starts with the analysis of the case on facts, page 136, Lordship. Para 35. May I read, Lordship? Page 136. Para 35, on perusal of the FIR, it appears that the incident took place on 18/2/2016. Again, at around 7:15 p.m. to 8 p.m., alleging Ajit Rangmo, Binglu Takeo, Arun Chetri, Vikas Boro, and Sagar Sabur as the prime suspected accused. However, during the investigation, Ajit Rangmo, Binglu Takeo, Arun Chetri, and Vikas Boro were discharged by the police for having found no involvement into the offense. After going through the available materials on records, this court had also agreed with the findings of the police to discharge Ajit Rangmo, Binglu Takeo, Arun Chetri, and Vikas Boro. As such, all of them were discharged from the charge of offense under section 302 and examined them as PWs. Initially, the incident was known to PW1 and she called PW3, who were busy in merrymaking along with friends in a half-constructed building near the distance of 20 to 25 feet from the PO. The PW1 also informed the relatives of the deceased. The PO lies within a distance of 12 feet from our house. The house of the deceased is around 50 feet from the PO. It is seen from the evidence of PW2 to 4 that the accused and the victim deceased were not present in half-construction building for merrymaking of playing guitars and singing. Nearby PO, which is a distance of around 25 feet from the PO. In this connection, I have also carefully perused P Exhibit 3 rough sketch map prepared by PW15 IO. It is also in the evidence of PW2 to 4 and PW6 that the accused and the deceased had a quarrel at Atobong during the daytime before the incident evening. However, it also in the evidence that the matter was compromised at Atobong between the accused and the deceased. PW3 came along with the deceased from Atobong to a place of juncture where he was dispersed with the deceased near his house. But the house of PW3 is not shown in P Exhibit 3. However, it is deposed that the PO is around 300 to 400 meters away from the junctures to the house of PW3. He gathered in the construction site within half an hour along with PW2, 4, and 6. And as per PW2, he along with PW6 left Atobong after gaping of 20 minutes after the decease, and PW3 left Atobong. He came to the shop of the accused as to know the injuries sustained by the accused, but the accused was not available in the shop while he was having cigarette at the shop of the accused. PW1 told them about the incident of the deceased. As per the evidence of PW4, Firoz, Ali Kumar, Toy, Arun, and PW3 were present at the construction site, playing guitars and singing. He heard the sound of a person running and tried to look at the sound of the running, but no one was seen. After 20 to 25 minutes, PW1 informed them about the incident. As per the evidence of PW5, the accused is his friend. The accused came to the shop at around 5 to 6 p.m. and left the shop to meet his supervisor from Mumbai. He also deposed that the deceased came to his shop in the evening time on the date of the incident. The deceased came first before the accused at his shop to have a cigarette. Later on, the accused came to his shop after the deceased left his shop. There was a gaping of half an hour time between the arrival of the deceased and the deceased in shop. The deceased took the footpath road 2 and the accused left the road 1 as shown in P Exhibit 3. He also deposed that as per the instruction of the police, he told the accused that the deceased was lying in unconscious state and the accused is one of the suspected person. He also asked the accused to come back to clear the matter. As per the evidence of PW8, one evening around 7 to 7:30 p.m., while he was closing the shop, the accused appeared in the shop and had purchased one marigold biscuit and cigarette. The police asked him about the boys visited his shop who have committed a fraud. Just then he remembers that he had seen one boy come to his shop with blood in his right hand while receiving cigarette. During the cross-examination, he was not sure that the accused standing on the dock was the person who purchased the marigold biscuit and cigarette. However, it is pertinent to mention here that during the examination of the accused under 313, the accused admitted to have purchased marigold biscuit and cigarette from the shop of PW8 and has no comments on noticing of the blood in his right hand at the time of delivery of cigarettes. As per the accused in his defense evidence and under section 313, time of arrival of the accused in the shop of PW8 was around 8 p.m. However, as per the evidence of PW8, it was 7 to 7:30 p.m. In this regard, I find that evidence of PW8 is found to be more reliable as the accused and the boy came while the shop was closing, and as such the incident of closing the shop is a remarkable point, and as a business practice, it is also a normal routine closing the shop at around 7 to 7:30 p.m. Further, it is also observed that the evidence of PW8 reveals that the accused came to his shop in between 5 to 6 p.m. Therefore, the accused cannot be present in at two places around 6 p.m. But beside, he had visited his house. Assuming it was for a time being, the accused left the shop of PW8 at 5:40 and reached at 6 in the shop of PW8. It is not possible to reach around 6 p.m. in the shop of PW8 as the distance between the shop of PW5 to PW8 is 25 minutes of walking distance as deposed by the accused during the examination as a defense witness. Further, it is also in the evidence of the accused that the daytime party at Ottobong was ended at 5 p.m. and he came back to his partnership shop with PW5 and left the shop at 5:40. As for the evidence of PW5, the accused came to the shop between 5 to 6 p.m. and stayed with him for half an hour and had supper food with him. Hence, the accused might have obviously taken some time to reach from Ottobong to his shop and stayed for half an hour with the PW and then reach the shop of PW8. As such, it would not be possible to complete all the process in 1 hour from Ottobong to the shop of PW8 besides visiting his own house. In view of the facts, it can be safely draw a conclusion that the accused had visited the shop of PW8 around 7 to 7:30 and also visited the shop of PW5 around 5 to 6 p.m. on the day of the incident. As per the evidence of PW17, he was present at the time of the recording of the accused by the police, during which the accused had admitted to commit the offense, and also before PW12, and for which the accused had no comments in his defense, as well as statement recorded under 313. On the basis of P Exhibit 3 and evidence of PW1, it could be presumed that the assailant met the accused, the deceased at PO, which lies 50 feet from the house of the deceased. Further, it is in the evidence of PW5 that the deceased left his shop half an hour before arrival of the accused, and the accused stayed half an hour with the PW5. Meanwhile, it is also in the evidence of PW13 that the deceased came to her house at around 5 p.m. and had supper food. The deceased stayed in her house for around half an hour. As per evidence of PW3, he had dispersed the deceased at the junction near to his house. Hence, it is possible that the deceased might have straight away visited the shop of PW1, which might be around 5 to 6 p.m. Therefore, he took the road number 2 shown in P Exhibit 3 and had supper food in the house of PW13. Therefore, he might have come out to join the merrymaking party in half construction site, which was around 25 feet from the PO and around 50 feet from the house of the PW13 and deceased house, as both houses are near as per PW13. As per the evidence of PW10, first IO, accused was brought back to Bhalukpong on being trapped that the deceased was alive in unconscious state and he was to provide necessary treatment, and PW5 while in custody. Hence, the accused came back to Bhalukpong. During the investigation, PW8 disclosed he saw blood on the face and cloth of the accused, and the accused was absconding. After the incident. Hence, the suspect of PW10 becomes more strong, and leading to the arrest of the accused. During the interrogation, the accused admitted to commit the offense. As per the accused, the deceased assaulted the accused first, and during a scuffle, a knife came into the hands of the accused, and he stabbed the deceased. As per the IO, the accused had a motive, as the deceased humiliated the accused as and when they had gathered. The weapon of offense could not be recovered as it was thrown in the Sunday market area, and the blood contained shirt were also thrown. Into Kameng River. Further, PW15, second IO deposed that he had examined 2 or more witnesses. As per his investigation, the motive was proof for revenge. He prepared P Exhibit 3. The accused disclosed that after committing offense, he took the road to Sunday Market located under Assam and came on the highway where he visited the shop of PW8. During discussion between the accused and the PW8, the accused admitted to have a fight with a boy. On the basis of the evidences, summarized findings can be drawn as under. A, the relation between the accused and the deceased was not good, and the deceased used to humiliate the accused whenever they gathered. As such, it can be safely drawn that the accused had a motive or intention to commit the offense as revenge. B, there are admissions of the offense by the accused before PW 12 and 17, for which the accused has no comments. As such, it can be presumed that the accused had made extrajudicial confession before PW 12 and also before PW 17. Then C, the exact time of the incident is not known to everyone. However, as per the FIR, it is between 7:15 to 8 p.m. As per the evidence on record, the time of the incident is around 6 to 7 p.m. The accused did not leave Bhalukpong before 7:30 p.m. on the incident evening, as per the evidence of PW8. The accused was present in and around the PO during the incident time, which casted more suspicions and strong evidences against the accused for non-explanation or unrealistic explanation made by the accused in his defense, which in turn complete the chain of circumstance. PW8, the evidence of PW8 and admission of the accused to have visited the shop of PW8 is a strong evidence against the accused to complete the chain of circumstances. Therefore, the accused abscond from the Balukpung. Therefore, the accused abscond from Balukpung, which is a strong evidence against the accused, besides other incriminating evidences. E, the evidence of PW5 reveals that the accused and the deceased left the shop in different directions in shown in P Exhibit 3, which the road is ultimately meet the PO. The evidence also reveals that he had trapped the accused to come back to Balukpung on instruction of the police. The evidence of the accused in his defense is not convincing. That the evidence, then the evidence of PW5 and 8 relating to the time of leaving and visiting the shop of PW5 and 8, as the case may be. Hence, the chain of circumstances is complete by itself. It is in the evidence of PW1 that she could hear the sound of a vomiting dog, which is 12 feet away from her house. Had it been the case of scuffle or quarreling, the PW1 would have been listened the scuffle or quarreling between the accused and the deceased. The PW1 heard the sound like a vomiting dog in the later stage while the deceased was about to die. On her arrival at PO, the deceased could not speak out. Hence, it can be presumed that it was not a case of quarreling or scuffle, but a case of a complete intention to commit the offense without giving any opportunity to make defense on the part of the deceased. It is also in the record of PW4 that they heard sound of running person, just 20 minutes of information of the incident from PW1, which tells this court that the person had either run to commit the offense or run away from the PO after the commission of the offense. Therefore, it can be presumed that it is not a case of heat of the moment or passion of the moment, but it was completely a design to attack the deceased before arrival at half construction site to attend with the merrymaking party.
Okay, just a minute.
Yes. Oh.
Okay. So, how much time do you take this? How much time will take, Mr. Ite?
I won't take much time.
But I don't need
That
to,
means,
hardly 20 minutes, my lord. Only on the fact, my lord. Otherwise, in judgment, whichever I have to reliable punishment.
and yes, sir.
My lord, at least half an hour. After the judgments, I have to point out some things and then some citations.
1 hour. See, we have our respective single benches also.
Yes.
So probably it might take another 1 hour or so. We'll have it tomorrow.
We would have agreed, but my lord, there are some reports that there is some one call tomorrow.
Huh?
So
One.
he's coming from Itanagar. Our house is not very near the High Court. So if not tomorrow, then day after tomorrow, my lord. Otherwise, we have no problem at all, of course.
No, we have heard you the entire thing today, but the thing is that since the single bench matters are also waiting in line,
Yes,
so since you are still yet to complete and
yes,
PP is yet to submit,
Yes, ma'am.
minimum 1 hour will be required.
yes,
So if we consume 1 more hour, that means 3 o'clock.
yes.
So hardly time for the single bench matters. That's why.
Day after, my lord, then. We're not very sure because tomorrow, if the one call is called up, then it'd be good.
No, till now there's no such kind of official,
Huh.
isn't it? We'll have it tomorrow. In
Yes.
case there's a band, then we take it up there.
Yes, my lord.
Please write down the hard in part. List again tomorrow. Huh? Please give the date. Second up,
Nine.
will sit
Tomorrow is 9th.
8.
No, 9th.
Tomorrow is 9th.
9th, madam.
List again on 9th. With the understanding that in case there's some difficulty tomorrow,
Yes, ma'am.
it'll spill over day after tomorrow.
Yes.
Second half, we're sitting as single benches.
Okay.
All right. Does it wind up mistakes? Yes.
That's one second, right?
Item 8. Yes, what do you want?
I think they will, it's 9th of, 9th of,
19th of? You're for the respondent. What is your good name?
on behalf of standing council, to the speaking department. Start.
Standing Council Education. Who is he? Standing Council? Okay. As requested on behalf of Mr. T. Tagum, Learned Standing Council, Education Department, and not objected to by the other side, list the matter on 19 January 2026. Nine and 10 also.
Selected.
Mr. Pagin is there. After 1 week? When?
Only fair out of there was to remember the property.
Okay, on the prayer made on behalf of Mr. T. Tagum, Learned Standing Council Education Department, and not objected to by the other side. This is the matter again after a week. Huh? 12.
Hello, my lord. My lord.
Hmm?
May I present okay, my lord? Hello, my lord, VC, my lord. Item number 12, this matter will be
Hmm.
taken up on Wednesday. Wednesday, my lord. Because we did not receive any call this today. Item 12,
Wednesday.
Wednesday.
Mr. Tagum, he'll be there on Wednesday? Okay. 12 list again on
Hello.
Wednesday.
Wednesday.
Yes. Yes.
And
As
item
per-
number
for-
18, my lord.
Just a
What is
minute,
the item?
let me pass the order. Item 12 as paid for on behalf of Mr. T. Tagum and not objected to by the other side. List again on Wednesday. Item 12. Yes, then?
My lord, item number 18, my lord. I've been told that they are going to take time. Item number 18, they didn't file any affidavit. Mr. Takmo has informed me that they are going to, my lord, take time to file affidavit. If it is so, my lord, I have no objection.
Who will be appearing?
Mr. Takmo, my dear. T. Takmo, Takmo.
Standing council education department.
Standing Council Education Department.
Already inspected. We have been inspected on behalf of.
When can you file your power and affidavit? Huh? Winter? Okay. Your good name? H. Thai. T.A. Mr. H. Thai, Learned Council submits that Mr. T. Tagum, Learned Council will be appearing for the sole respondent. And he prays for 3 weeks' time on his behalf to file power as well as the show cause reply in the form of affidavit. Stop. Mr. A.K. Prukasta, Learned Council appears through RVC. Next para, in view of above, list this matter. Immediately after the winter vacation, on a date to be fixed by the registry. respondent to file the show cause reply in the meantime. Yes.
More obliged, Your Worship. Obliged.
Who's there for the other side? What is your good name? P. Pangu. Ms. P. Pangu, learned State Counsel appearing for the state respondent, submits that she is yet to receive instructions in the matter and therefore prays that she may be given 3 weeks' time to receive instructions and to file counter affidavit. Prayer is allowed. This again after 3 weeks on a date to be fixed by the registry. Item 13 and 14, same. 20? 20 and 21. What do you want? 18th of this month. Okay, on the prayer of Mr. T. Tapa.
They have just come up on their method. I am very with that comments I did not ready to get. This matter is with regard to then release a land competition. On the last occasion, as the government has mentioned the matter, on the matter, come up to put it on.
So 22nd. 22nd.
After
2 weeks means 22nd. It will become.
I am not mentioning. They are mentioning.
It is not urgent today. It is not urgent today. It will become urgent after 2 weeks. Huh? Then? See, there's hardly any time. 22nd means 2 days, 3 days. You have it on reopening, Mr. Counsel. Okay, on the prayer made by the learned counsels for the parties, let the matter be listed for hearing on 7th January. All right. Yes. How much time? You're for power department. Okay. 2 weeks. Okay. Ms. P. Sangeeta, learned government advocate appearing for the state respondent, submits that she has received Paraway's comments and prays that she may be granted 2 weeks' time to file counter affidavit. Praise allowed. List again after 2 weeks. Yes.
Number 16.
16. But why is it listed today for orders? 6. You're for private respondent. Number 3. You want some more time? How much time? 3 weeks. Your good name? On the prayer of Mr. S. Irang, learned counsel for respondent number 3. Further 3 weeks time is granted for filing counter affidavit. List again after 3 weeks. All right.
Item number 1.
Order by which the petitioner to our counselor of their village, it's often.
Hmm.
Now, the Gaonburas are not members of the village authority. They are appointed under section 5 of the Assam Frontier Regulation.
Hmm.
Now, the regulation itself provides under section 5 the appointment, but the mode and methods are not provided. So, my lord, the government, my lord, to supplement the statute, has framed this with the guidelines at page 29. So, the guideline.
Hmm. Yes.
Clause 4, your lordship will find at page 33. This is what would disqualify a person to be appointed as a Gaonbura.
Clause 4.
Clause 4, at page 33.
Hmm.
Is convicted of criminal offense, habitual offender, primary member of a political party, moves out of the village and lives in some other place.
Hmm.
That's it. Then, my lord, at page 34, lordship will find the powers and responsibilities. I'm going to skip it, my lord. And then your lordship will kindly have page 37. Dismissal of head Gaonburas and Gaonburas.
Yes.
The appointing authority can dismiss any person appointed as if she becomes disqualified as per disqualification mentioned above. That is clause 4. The performance is not satisfactory. Head GB will continue in service subject to the satisfaction of Deputy Commissioner. Principles of natural justice will be followed in dismissal of head GB and GB. Then 9, my lord, punishment for misconduct. Without prejudice to any punishment to which she may be liable under any other law, a head Gaonbura shall, for any misconduct in the exercise of his functions under the Assam Frontier Regulation, be punishable with a fine which may extend to ₹1,000 or with imprisonment of either description for a term which may extend to 6 months on conviction by the Deputy Commissioner / Additional Deputy Commissioner. So either he can be dismissed or this is the punishment for misconduct. This is the only two things. If your lordship now have page 41, this is the appointment order. I'm just pointing it out. I don't bother your lordship with that. This is the appointment order of the petitioner number 1. Your lordship will find he has been appointed under section 5 of the regulation.
This is the petition number 1.
Petitioner number 1, my lord.
Okay.
Then at page 43 is the appointment order of the petitioner number 2.
Hmm.
Now your lordship will kindly have page 45.
Hmm.
My lord, though, my lord, in the state of Arunachal Pradesh, we have a land settlement act 2000. But my lord, regarding position and ownership, there no any law, my lord, to declaring position and title. So the land position certificate is issued for private lands, my lord. That is based on a guideline, my lord. Now the application itself, my lord, provides a column where the, my lord, no objection has to be taken from the Gaonburas. This was an application, my lord, submitted by one Lombotang. He was the, my lord, representative of that constituency for the last 5 terms. So in 1996, the villagers themselves gave him the plot of land. It's a gift. It was just basically, who is our pleaded case, it was basically because there's a river running just on the backside of the village, it was causing erosion. The villagers expecting that since he was a minister at that point of time, maybe he can do something. Since his land will be there, maybe he will do something, maybe government funds and just to put embankments there. So that is how it was given. No written document, nothing. This was 96. So problem starts, my lord, because now the Indian Oil IOC, my lord, corporation has started surveying for oil there. And there's been rumors are afloat that oil has been found. So that is why all these things have actually come up. So the application itself has a format where the Gaonbura has to put his seal and signature. You also will find it below, my lord. Standard format for head Gaonbura certificate. The Binod, the petitioner number 1 has below signed it. So it was known to all villagers that it is his land.
Where is that signature?
Signature, my lord, below part, my lord. This may be treated as no objection certificate for issuance. His lordship got it.
Page number?
46.
Okay, 46.
Yes.
So,
So I've put it the signature. The format itself requires it. At page 47, your lordship will find the other Gangpura has put the signature. Now, against this, my lord, a group of villagers at page 49 submits an objection regarding the application submitted by the said Lombotang. Your lordship will find page 49. Objection to land position certificate application by such and such, such and such. Thereafter, your lordship will find at page 56. This is another complaint regarding unauthorized fencing. Then your lordship will kindly have page 58. The petitioner number 1 and 2, since he had applied for a land position certificate, we give this declaration at page 58. Declaring that, my lord, the land belongs to the applicant. This was, my lord, done before a notary public. Then your lordship will find at page 64. These are irrelevant at this point of time. I will skip it. These are persons who have now withdrawn the complaint and all. Before that, my lord, at page 75, lordship will kindly have. This is in local language, the type of translated copy, the page 76. Just to show, my lord, how this is started.
Page 74.
76, my lord. Translated copy. This is to inform you all that everyone in the village is talking daily about the matter of oil. So this is how actually the issue started. So we all together must discuss about the matter so that there will be no misunderstanding of party politics in between us in the village. I'm just showing it for the purpose that this is the reason, my lord. Then, my lord, will kindly have page 77. This is submitted to the circle officer by 13 persons requesting for initiation of a no confidence motion. Now, my lord, the statute as well as the guidelines does not provide for any no confidence motion. It is in the discretion of the deputy commissioner. He can dismiss me by following the procedure of natural justice. This application, my lord, was forwarded at page 80 to the deputy commissioner. Then your lordship will kindly have page 81. It was further thereafter forwarded back to the additional deputy commissioner at Mebo. Page 81. Then 82, my lord, is the written reply furnished by the petitioners. Then your lordship will have the impugn order at page 91. This is passed by the deputy commissioner. My lord will kindly note the application was first forwarded to the deputy commissioner, then he forwards it back to the additional deputy commissioner. Now this order is passed by the deputy commissioner. May I read?
Yes.
Whereas a complaint was received in the office of the such and such regarding wrongful certification of village community land by Gangpura Mayor Village, whereas the complaint was sent to ADC Mebo on 31/7 to examine the matter and submit an inquiry report on the same. Whereas ADC Mebo has submitted an inquiry report, I will kindly note this, giving reasonable opportunity to the accused party and gathered evidence based on office records and facts. Whereas it has been observed in the report that the Gangpuras of Mayor Village, namely such and such, despite having full knowledge about the prevailing situation regarding the complaints related to ownership claims by one party and in sound mind have deliberately filed affidavit before the notary public in their official capacity using seal of Gangpuras, stating that the land belongs to the said party without holding trial in customary court or any other appropriate public hearing amount to negligence of the official duties of Gawabura by violation of section 22 of such and such. And whereas as per a statement produced by accused Gawaburas, it is clear that the same land had disputed ownership and it was the knowledge of the said Gawaburas. Now, therefore, as per the powers vested with the Deputy Commissioner under section 5(1) and guidelines thereof, Sri Sasensus is hereby put under suspension for a period of 8 months from the date of issuance of this order. Now, my lord will kindly note, while passing the impugn order, an inquiry report by the Deputy Commissioner has been taken into account. It appears that the Deputy Commissioner has made some inquiry. We were obviously called. He made some inquiry, had some finding, and the report was submitted to the Deputy Commissioner. And based on that, my lord, this finding has been arrived at. And that inquiry report was never furnished to us before passing of this impugn order. Secondly, my lord, the guidelines does not provide for any suspension of Gawaburas. You can dismiss him very well, my lord. And for misconduct, there is a provision for fine and imprisonment up to 6 months. Neither the statute nor the guidelines provide for any punishment of suspension. And to top it all, this was all on the basis of an inquiry report which was never furnished to the petitioners. My lord, as regard to my lord non-furnished, relying upon an inquiry report and not furnishing to the petitioners concerned, my lord, I am just relying upon a judgment of our own High Court. My lord will kindly have paragraph 17 at page 8. Paragraph 17. In the instant case, a perusal of the records produced in original by the learned counsel for a respondent would go to show that after the FIR dated census was filed, the officer in charge of the Jalukbari police station had himself made an inquiry in respect of the incident and submitted a detailed report to the Superintendent of Police, City, on 7803. The said report, which is available in the record, would go to show that there are specific details revealed by the inquiry, including the names of persons responsible for the acts alleged and the relationships with the prisoner number 1. The report of the Superintendent of Police dated, though based on the said report of the officer in charge, Jalukbari, omits the details available in the report of the officer in Jalukbari Police Station. The order passed in a note sheet recommending cancellation places reliance on the report of the officer in charge as well as the letter of the superintendent. Yet the petitioner was not given a copy of either the report or the letter in question. The order recommending cancellation is available in the note sheet which was approved by the chairman of GMDA would further go to show that the cancellation was recommended relying on the second report of the Superintendent of Police dated as containing similar allegations of extortion against the prisoner number 1. The said aforesaid second report finds mention in the order of the cancellation, yet the allegations contained in the aforementioned second report were not even pointed out to the writ petitioner. These materials available to respondents, in their view, may be adequate to sustain a satisfaction that the contract ought to be cancelled, but such satisfaction cannot be unilaterally reached without affording the writ petitioner an opportunity of controverting the same or to put forward its version of the matter. The facts narrated above, as it leaves the court with an indelible impression that the writ petitioner was not afforded a full, complete, and adequate opportunity to meet the allegations leveled. Here also, my lord, the impugn order categorically relies upon the report of the additional deputy commissioner, based on which the findings have been arrived by the deputy commissioner, but that report was never furnished to us, my lord. That's my humble submission. My lord, I'm praying for an interim of prayer also. Yes, that is there. Otherwise, my lord, since there's some urgency in the matter, my lord may direct the respondent authorities to file their affidavit without fail, my lord. Next.
Are aggrieved with the order dated 24/9/2025, bracket annexure 14, issued by the Deputy Commissioner, East Siam
East Siam.
District, suspending the petitioners who are the Gaumburas of Mayor Village for a period of 8 months from the date of issuance of the order. The Learned Council submits that purportedly on the basis of some inquiry report, which otherwise was not even made available to the petitioners. The Learned Council also submits that as per the guidelines for appointments of Gaumburas in the state of Arunachal Pradesh, there is no provision for suspension of Gaumburas except for dismissal or disqualification. Stop the interview order being bad in law, the same should be set aside. Next para, in view of above, issue notice of motion returnable by 4 weeks. Ms. G. Ate, additional senior government advocate, accepts notice on behalf of all the respondents, and therefore no fresh notice is required. We'll stop having regard to the projection made by the petitioners. The matter requires appropriate examination and also early disposal. So accordingly, the respondents shall file their counter affidavit within 3 weeks from today. But after, the matter will be taken up for admission hearing. List again on so and so. We'll give you a date on
I have also,
Hmm.
applied the court before lots of, because of the election lots of, election.
no, so we'll give you enough time. We'll be open.
They may not be able to, within these 3 weeks, they will not be able to give any instruction to us.
Elections are over in 10 days, man.
Understood.
21st of January.
Yes, sir.
Enough time.
Yes.
Yes.
List on 21st of January.
Item number 2.
Marvelous, madam.
Yes.
My lord, the matter before the lordship is pertaining to service matter. Here in this matter, my lord, basically, I'm challenging the order passed by the commissioner on 17/1/2024, whereby my lord, the private respondent has been absorbed in the my lord, in my department.
Who is that?
Now, my lord, this will be lordship will find in page number 30,
30.
my lord.
Private respondent number
Respondent number 6.
6.
Yes. My lord, got in page 30.
What? There are 2 persons. Which one of them?
I'm against the first one, my lord.
Techi Yami.
My lord.
Respondent number Respondent number
6.
6.
And in respect of the other one that I'm not questioning about it.
Absorbed as what?
Absorbed as assistant engineer in the department of ULB, my lord. This is respondent number 5. In fact, my lord, what it say, consequence upon the acceptance, my lord, in page 30,
Just read.
consequence upon the acceptance of the option exercised by the employing junior engineer for the administration of the department on the urban local bodies and on the basis of no objection certificate issued by the parent department, the government of Arunachal Pradesh is pleased to absorb permanently to the employing juniors in the department of the urban local bodies as the assistant engineer in the interest of the public service for existing skills which apex from consequent financial such and such. Now, my lord, now my brief facts behind the case is, my lord, while I was serving as a, my lord, junior engineer in the department of the WRD, my lord, I come across that the creation of the post in the newly ULB department, my lord. And accordingly, on applied to the post, I was on the appointed on the deputation on 6/3/2019, my lord. My lord will find my appointment order in page number 23. My lord, may I kindly come back to the page number 23.
Yes.
This is my past appointment on deputation, my lord. Thereafter, my lord, my parent department has issued a no objection of certificate to absorb in that borrowing department. It's appeared in page number 24. And my lord will find in the my extension in page number 25. And lordship may kindly come to till page number 29. That my extension in the deputation period has been extended up to 8/3/2027. My lord, page number 29.
You've gone on deputation.
My lord,
From which
I
department?
am serving as assistant engineer on deputation since
In you're
6 March 2019.
you're from the town planning.
No, my lord, I am from the, my lord, this water resource department,
Water resource. Okay.
my lord. Initially, my lord, this town planning and the ULBs were the same department. But in the midst of the years 2023 and 24, these two, this department has been bifurcated into two respective department. Now, my lord, I am concerned with the ULBs, my lord. No more this town planning and the ULBs are in the same department, my lord. This need to be, my lord, clarified. Now, my lord, in the meantime, my lord, what my contention is this, the private respondent was, my lord, on the functional basis. Now, I'll let to the lordship to the history of the private respondent. My lord, may kindly come to the page number 36. The original copy in page number 36 and the type copy in page number 37, my lord. My lord, 37. In the interest of the public service, Mr. Sensas Junior Engineer, who was transferred from APPWD Urban Development on the deputation basis, white number such and such dated 31st December 2013 is hereby posted under the Pasighat Municipal Corporation, known as PMC, my lord, as the assistant engineer civil with immediate effect till such time the municipal recruit its own cadres. My lord, the language is very clear. She has been posted for my lord functional basis till my lord requit its own cadres, my lord. And my lord may kindly come to page number 39 now. That in page number 37, it has my lord report about the deputation. But the clarification has been made by the parent department, my lord, on page number 39. It appears, my lord, this is corrigendum to the earlier on the page number 39, my lord. Number such and such. Consequence upon the transfer and the posting of junior engineer from the Arunachal Pradesh Public Work Department to the Urban Development Department, transfer of Ms. such and such junior engineer, my lord, may be treated as transferred with post instead of transferred on deputation, my lord. My lord, the language is very clear. Her transfer may be considered on with transferred instead of transferred on deputation. Meaning, my lord, the private respondent has never been on the deputation. She was transferred with the post, my lord. And finally, my lord, she was transferred back to the IMC, Itanagar Municipal Corporation, a PMC from the IMC, my lord. And I'll take to the lordship to page number 46. Here is the noting of the department, whereby the my lord, the department said that they, my lord, got it, Annexure K, page 46.
Yes.
In the table column, my lord, in serial number 6, at present, the following posts are posts at A, IMC, and IMC on the deputation temporary basis. Name of officer. The first one is my lord, private respondent, posting from UD department with effect from 9/1/2014, my lord. This has been reflected. This is also wrong. In fact, my lord, he transferred on 2016. Thereafter, no deputation has been, my lord, why I am showing this honorable court is no deputation, word of the deputation has not been reflected, my lord. And my lord may kindly come to page number 53. Here also, my lord, same thing has been reported, that posted from the UD department. And as I have already shown to this honorable court, the her posted was on the functional, my lord. And my lord, page 53. My lord, page 53. Here in the same thing has been reflected, my lord. Posting from UD department, my lord. So these all are the official noting, my lord, on assuming that she has been transferred from the UD department, and no, the word of the deputation was not, my lord, reflected. But if, my lord, we go through the impugn order, that the impugn order that the 17/1/2024 in the page number 30, it's, my lord, showing that this period of the deputation. Therefore, my lord, my case is that I am the person who is on the deputation since 2019 in the my lord, department. And at the same time, the other person is also in the department, but her service never been on the deputation, but she has been transferred with post. My lord, when they transferred with post mean, my lord, she had to, my lord, attach with her, my lord, original post of the junior engineer. Here in this case, my lord, while he was transferred from, initially he was from the PWD to UD and UD to IMC. While report to the IMC from the UD, the word deputation has come in her case. But despite of that, on 10th February 2016, my lord, the parent department has already clarified that her posting maybe her transport is, my lord, with posting instead of deputation. Therefore, my lord, my case is that since from the date of the deputation in the department of the ULB, since 2019, I am in the post of assistant engineer. Therefore, if the department is to be considered, my lord, my case should have been considered first, my lord. The other one was on the junior engineer. Therefore, first of all, she had to absorb. But the impugned order before the lordship has clearly shown that she is also on the deputation, which is not at all in the record, my lord. My lord.
Please write down for Mr. C. Modi, learned counsel for the petitioner, who submits that the petitioner is aggrieved with the absorption of the respondent number 6.
5, my lord.
Absorption of respondent number 5.
My lord.
As assistant engineer in the Department of Urban Local Bodies.
By the order dated 17/1/24, my lord, Annexure H.
Provide order dated 17/1/2024, bracket, Annexure H. Despite the fact that he or she, Techi, she,
My lord.
despite the fact that the respondent number 5 was transferred along with her post to the Urban Development Department, bracket erstwhile, from the Public Works Department, while holding the post of junior engineer. On the other hand, petitioner has been serving as assistant engineer in the Department of Urban Local Bodies on deputation since 6/3/2019. And the vacancies in the post of assistant engineer is to be filled up through absorption from the feeder post from officers on deputation. So therefore, by the impugn order dated 17/1/2024, insofar as the respondent number 5 is concerned, the petitioner has been clearly been wrongly denied of his chance for absorption to the post in question. And therefore, the absorption of the respondent number 5 should be interfered with by this court. Next para, in view of above, issue notice of motion returnable by 4 weeks. Ms. P. Pangu, learned government advocate, accept notice on behalf of order number 4 only. Then who are they? Petitioner to serve notice upon the respondent numbers 1, 2, and 3 through the Standing Council of ULB Department.
Mal.
Stop petitioner shall take steps for service of notice upon respondent number 5 by registered post with ADU within 3 days. List again after 4 weeks.
Offline.
Item number 3.
Yes. My lord, I am for the petitioner, K Square Motors. In this case, petitioner is being saddled with a GST demand under a provision not in existence at the time of alleged act and on a ground never disclosed in the shockers notice, thereby denying the petitioner any opportunity to defend. My lord, I have availed the ITC under section 16(4) of the CGST Act. Petitioner has availed ITC of rupees 94.4 lakh for March 2021, strictly as per the provision of law in force at that time. Petitioner was issued shockers notice alleging delayed claim
Yes, please carry on. Go on.
21 in the books of accounts and already intimated to the department at Annexure 9, page 94. Page 94, my lord. Page 94.
Yes.
Yes. Here, intimation regarding non-final GST at 3B for March 21 is reported due to financial constraints. And here I have claimed eligible input tax credit 94,54,391. That is ITC eligible. I have already intimated on 7/4/2021 to the jurisdiction Central Jurisdictional Tax Authority at Naharlagun. My lord, normally this ITC was always taken in the books of accounts in case of service tax under the Finance Act 1994 and in case of central excise duty under the Central Excise 1944. So at the initial stage, GST, when introduced in 2017, at the time system was not properly functioning and many of the activities in the GST, including ITC, were done manually. So we have taken ITC before 30/11/21 in the month of April 2021 and intimated to the jurisdictional officer on 7/4/21. So I have complied the section 16(4) of the CGST Act. Now demand was confirmed under section 16(5). The demand has been confirmed under section 16(5), a provision which was enacted in 2024, introduced a new substantive condition that ITC must be availed in section 39 return, which was not in existence in 2021. This ground was never part of show cause notice and the petitioner had no opportunity to defend it. So I will refer page 35, show cause notice. Page 35, para 13. In the show cause notice, 5th line, in contravention of provision of section 16(4) of the said act. 5th line, para 13. That is in the show cause notice, it is written in contravention. I have taken ITC in contravention of provision of 16(4). And in the order original, my lord, at page 47. 47. Last para. Page 47.
Yes.
Para 85. That is last para. Hence, the said ITC availed and utilized is inadmissible in terms of provision of section 16(5) of the CGST Act. That is in the order original. So, in show cause notice, it was written contravention of 16(4). In the order original, it was written contravention of section 16(5). Both these provisions are starkly different. 16(4) do not mandate how to take ITC, whether in the return or in the books of accounts. And 16(5) enacted in 2024 and mandate it should be taken in the return for financial year 17, 18, 18, 19, 19, 20, and 21. It is for the SSC, those who missed to avail the ITC in terms of 16 subsection 4 deadline, that is 30/11/21. I will show the GST provision, my lord, at page 70. 16(4), which was written in the show cause notice that I have availed ITC in contravention of section 16(4). Page 70, my lord. 4.
'74.
Page 70.
Page 70.
70.
Yes.
GST provision in section 16(4), that is existed before the amendment. A registered person shall not be entitled to take input tax credit in respect of any invoice or debit notes for supply of goods or services, or both, after the 30th November, following the end of financial year to which such invoices or debit notes pertains, or furnishing the relevant annual return, whichever is earlier. So here, 16(4), take that there is no mode has not been mentioned. 16(4) did not say how I will take, in which way, whether in the books of accounts or in the annual return. So 16(4) mandates ITC not to be availed after 30/11/2021. Petitioner duly availed ITC in April 2021, as I have already shown your lordships at page 94, that I have availed in books of accounts and I have intimated to the department on 7/4/2021 in the books and intimated to the judicial officer. Then there is no dispute about this. So section 16(4) prescribes the outer time limit for availing ITC. Now, my lord, I will read section 16(5). 16.5, which was inserted by the Finance Act of 2024. Notwithstanding anything contained in subsection 4, in respect of any invoice or debit note for supply of goods or services or both pertaining to the financial year 2017-18, 2018-19, 2019-20, and 2020-21. The registered person shall be entitled to take input tax credit in any return. Here, my lord, important, in any return. There are two types of monthly return and annual return. So in any return, it is written. Section 65, which was inserted in 2024 under the Finance Act. And my claim is in 2021, wherein 16.4, there is no mention how I am to take it. Now, so which is filed in the 30th day of November. So ITC, this 16.5 says ITC to be availed in the return for 17, 18, 18, 19, 19, 20, and 21, 2021. It is for those SSC who missed to avail ITC in terms of section 16.4 deadline, that is 30th November 2021. So this 16.5 was non-existent at the time in 2021. So it is a violation of Article 265. So now, my lord, so my case is that Shockers notice issued contravention of 16.4, but in order origin it was confirmed under section 16.5. So this is a jurisdictional challenge is that demand initiated alleging contravention of section 16.4, but the confirmed under section 16.5. This fatal variance between the charge and the basis of adjudication renders the entire proceeding ultra vires and void. So, my lord, both are starkly different, and there is a gross violation of natural justice and constitutional mandate. The petitioner cannot be penalized without being given an opportunity to defend, nor under a provision that did not exist at the time of the act, nor on a ground never alleged. Such adjudication is ultra vires, arbitrary, and without jurisdiction, having traveled beyond the Shockers notice, my lord. Expressly contrary to Article 141, it violates Article 14, 19, 20, and 265 of the Constitution, as no tax can be imposed or recovered without a clear authority of law. So this is an ultra vires and void. This Shockers notice, order original, and appellate order.
All right, so we'll issue notice.
Yes,
my lord, in this case, my lord, I am appearing for the suborder number 2, 3, and 4, my lord. So I only want to bring your attention this honorable court on section 112 of the GST Act, which provides for the provision of appeal to the appellate tribunal. And the petitioner would appeal before the appellate tribunal. And this honorable court in WPC 2747 of 2023, in Ayush Chandra Hospitals, Guwahati Private Limited versus Union of India others, in a similar case, was remanded by the matter to dismiss the case and directed the petitioner to appear before the tribunal, which is the Central Excise and Service Tax Appellate Tribunal, is Regional Bench, Kolkata. So before coming to this, my lord, they should have come because as per the judgments of the Supreme Court, both in Whirlpool Corporation as well as the judgment of this Radha Krishna Industries, my lord, the Supreme Court clearly stated that there are certain grounds under which when the alternative remedy, rejurisdiction can be availed in existence of alternative remedy. It says that when there is a violation of fundamental right or a principle of natural justice, or the proceedings are wholly without jurisdiction, or when it challenges the values of any act. In this case, nothing as such has happened.
Mr. Boro,
And yes, my lord.
Where does the appeal lie?
In the, my lord, this is a tribunal, state, my lord.
My lord, no, GST tribunal has not yet constituted.
My lord, GST tribunal has not been constituted, but
Yes.
the matters are being heard at the Central Excise and Service Tax Tribunal, East Regional Bench, Kolkata.
No, my lord, that
My
is
lord,
for sister Kolkata, that is for service tax and customs, these matters. And for GST tribunal has not yet constitution, and this petition, there is no efficacious remedy, adequate remedy. This is the only remedy, my lord, because I have cited few Supreme Court decision. Case 84, my lord. Godrej Sharali, my learned friend, has pointed out that the petition seeks to enforce any fundamental right. Here my fundamental right is being violated. Principle of natural justice violated. My lord, show cause notice was issued under section 16.4 and it was confirmed under section 16.5. So I have not been no opportunity to defend myself. So here violation of principle of natural justice is there, my lord. So this is this is without jurisdiction. So
my lord, I will file my affidavit, my lord.
So
notice
that
that will be issued.
regarding the maintainability will be left open. You may
My lord,
raise your objection.
yes,
All right.
my lord,
You
my
are
lord.
Mr. Das Gupta,
Yes, my lord.
Nihar Das Gupta.
Yes, my lord.
You are senior counsel.
Yes, my lord, for the petitioner.
Senior advocate.
Yes,
Heard
advocate.
Mr. Nihar Das Gupta, learned senior counsel, assisted by Mr.
Techi Itatara.
H.
Techi Ita.
Techi.
Yes. It is in cause list.
Techi Itatara through RVC, who submits that the petitioner is an authorized dealer of Tata Motors located at Naharlagun, Arunachal Pradesh, and has assailed the jurisdictional validity of the show cause notice dated 5/6/2024, culminating to order in original dated 25/2/2025, passed by the Assistant Commissioner, Central Goods and Services Tax, Itanagar Division, and also the order in appeal dated 11/9/2025, passed by the Additional Commissioner, bracket appeals, comma, CGST, Central Excise and Customs, Guwahati. Now, by the said order, a demand of rupees 9454,391, along with interest and penalty, has been confirmed against the petitioner on the purported ground of delayed availment of input tax credit, bracket ITC, for the period March 2021. Next para, the learned senior counsel submits that in doing so, comma, there has been serious breach of principles of natural justice and the show cause notice alleging contravention of section 16 bracket 4 of the CGST tax, the CGST Act 2017 has been confirmed under section 16 bracket 5 of the same act. Copy submits that. There has been a fundamental departure between the charge in the notice and the basis of adjudication, which has vitiated the entire proceedings as being ultra vires, without jurisdiction and violative of principles of natural justice, since the taxpayer could not have been condemned for an offense under a provision that was not part of the statute when the alleged act had occurred. Stop. In this connection, learned senior counsel relies upon case of Oryx, ORYX, Oryx Fisheries Private Limited versus Union of India, 2010, 13 SCC 427. Next para, in view of above, issue notice, a motion returnable by 4 weeks. Mr. M.K. Boro, Learned Standing Counsel, CGST and Customs, accepts notice on behalf of
2, 3, and 4, my lord.
respondent numbers 2, 3, and 4, while Mr. N. Sora, Learned Counsel, accepts notice on behalf of Mr. M. Kato, Learned DSGI, who represents respondent number 1. Stop. Notice is therefore complete. Petitioner to serve requisite copies of the writ petition to the Learned Counsels appearing for the respondents today within 2 days. Stop. The issue about the maintainability of the writ petition is left open to be decided at the appropriate stage. Respondents to file their response by the next returnable date. List the matter again after the ensuing winter vacation.
Item number 4.
Obliged.
But the matter rests in a very narrow compass. The petitioner is a senior grade APSS officer. So then all his cases for promotion to senior grade and then admin grade is under seal cover for 2 reasons, my lord. The first is that he has allegedly issued 152 numbers of arm license while serving as SDO in charge in Sangram. That is one. And secondly, my lord, the second was there was a criminal case pending against him. Now that criminal case has been he has been discharged. So now today, my lord, I would only seek the kind indulgence of my lord to item 16, order dated 16/3/20, 9/10/2025, my lord, page 63. No, sorry, 25. Sorry, my lord, page 57. Here, my lord, detail of the case will find, my lord.
This is what, second round?
This is third round.
Third round.
Third round.
And this page 57 is the second round?
The page 57 is the second round. my lord.
Is the second round?
Yes. Somehow I got reinstated him in the service, and after passing this order, he did not contacted me. Otherwise, I could have invoked contempt jurisdiction. Well, kindly come to page 58, my lord. Well, I just 2, 3, 5 a small paragraph. I read that. I read 2, my lord.
Yes.
The read petitioner, who is an Arunachal Pradesh Civil Services senior grade for short APCS senior grade, has filed this read petition with 2 prayers which are as under. A direction to the respondent authorities to promote him to the Arunachal Pradesh Civil Service Selection Grade and Admin Grade for short APCS so and so from the date his batchmates were considered in the DPC held in the year 2018 and 21. My lord, if my lord, this basically talks about the supernumerary post creation and the promotion. My lord will remember that ONGC case, RK Sethi versus ONG case, 1997 case. Although I'll not go into this. To direct the respondent authorities to promote the petitioners to APCS admin grade on ad hoc basis, my lord. Now, 3, the petitioner who was working as an APCS senior grade was put under suspension on 13/02/2018, and pursuant thereto, a memorandum of charge was served upon the petitioner on 25/2019 inter alia for illegally issuing 152 numbers of arms license. Pursuant to an order of this court dated 10/2/2021 passed in WPC number so and so, the petitioner was reinstated on service as APCS senior grade. A departmental promotion committee DPC meeting for promotion to APCS selection grade from APCS senior grade was held on 27. My lord will mark this particular date, 27/7/2018. In which proceedings, the recommendation of DPC in respect of the petitioner was kept in a seal cover because of pendency of SIC vigilance case number 03/2018 under so and so, so and so, so and so, so and so. While the petitioner is working as an APCS senior grade officer pursuant to his reinstatement in terms of order dated 10/2/2022, passed in WPC number so and so, the recommendation of petitioner by the DPC held on 27/7/2018 continues to be under seal cover, and accordingly, the petitioner at present is working as APCS senior grade. My lord, kindly, I'm pausing for a moment. My lord, kindly see this page, discharge order at page 42, my lord. The case which they have taken the ground to keep me under seal cover.
This was by the special court?
Yes, a special court, my lord.
Any appeal pending?
No, no appeal is pending, my lord. That is the discharge order because there was no evidence against me. So I was discharged from that proceedings. Now, my lord, the second thing my lord will ask me, what is the status of the disciplinary proceeding, my lord? Till today, my lord, the charge sheet has not even been filed. That my lord will see at Annexure 1 series, my lord.
Disciplinary proceedings?
Disciplinary proceeding is still going on, my lord. My lord, kindly see 2019 and we are in end of 2025. 7 years gone.
What is that?
Well, that page 26, my lord, that is 27/5/2019 is the charge sheet memorandum of articles and reply that I have submitted, my lord. No charge sheet, even nothing has been done, my lord. So prolong. In any case, my lord, I am not
Presently, where are you posted?
Changlang as EAC. Well, my lord,
ESC.
EAC. My lord, my batchmate even has got the admin grade selection senior super time scale inducted into the IS. So when I am lurch here. Per se, I have been parked because of this scene, my lord. So, but this scene can be overcome by the OM, my lord.
Okay, you were just reading that earlier order of this court.
Yeah, I am reading that.
So that
Now, my lord, today I
that has
have
concluded, isn't it?
yes, my lord, I have only limited prayer today because my prayer number 1 and in my interim also, I have said this court has prima facie found. My lord, kindly see. I will not refer to para 7. Well, 9 and 10 is important, my lord. Because the fact will remain same, my lord, up to para 9. Here, the finding of the Honorable Single Judge. I think it's,
There is already a direction.
yeah, there is. My lord,
And since you have
because
come late, that's why
that's why, my lord,
you have filed as writ petition.
correct, my lord, because the contempt has a life of 1 year only, my lord.
So
And then my client.
on that note, we issue notice.
No, my lord, that's why I'm just making a request today.
Ah.
Only the prayer number 1 and my interim prayer also speaks for enforcement of this particular order. And for that, my lord will have to read this if my lord can take some pain with me. Para 10, my lord. Para 9 and 10, my lord. Kindly come to para 9 and 10, my lord. In the instant case, what has been noticed is that the petitioner who was earlier put under suspension has been reinstated in service as APCS senior grade pursuant to the order of this court dated 10/2/2022 passed in WPC number so and so. And the petitioner is working as an APCS officer, APCS senior grade officer. What has further been noticed here is that case of the petitioner for promotion to the post of APCS selection grade from post of APCS senior grade was kept in a seal cover in DPC held on 27/7/2018. The SIC vigilance case because of the pendency of which the case of the petitioner was kept in seal cover in a DPC held on 27/7/2018. is stated to be still pending against the petitioner. More than 4 years have expired since the case of the petitioner for promotion to higher grade was kept in a seal cover. In view of, well, kindly say, in view of the above, I find that the petitioner case for ad hoc promotion to a higher grade merits consideration by the appointing authority in the light of clause 5 of OM dated 14/09/1992. This is reiterated. So therefore, my lord, it is a fit case for disposal at motion stage itself, my lord.
No, what is this clause 5?
Clause 5, my lord. Clause 5 is reproduced at, my lord, para 7. Para 7 of the judgment. In so far as the second prayer of the petitioner seeking promotion on ad hoc basis is concerned, the petitioner has enclosed an office memorandum dated 14/9/1992 issued by the Ministry of Personnel, Public Grievances and Pensions, Department of Personnel and Training, white number so and so, clause 5 of the OM dated 14/9/1992 read as under. In spite of the 6 monthly review referred to in para 4 above, there may be some cases where the disciplinary cases, criminal prosecution against the government service is not concluded even after expiry of 2 years from the date of meeting of the first DPC, which caps its finding in respect of the government servant in a seal cover. In such a situation, the appointing authority may review the case of the government servant, provide that he is not under suspension. Here, my lord has seen that by this order, I was revoked. By order dated 10/2/2022, order 10/2/2021, my lord, I was reinstated in the service. So I am not under suspension. Had it been a case of suspension, my lord, under suspension, my promotion on ad hoc cannot be considered. That's law is well settled, and I cannot agitate beyond this point of law also, my lord. Now, my lord, A, whether the promotion of the officer will be against the public interest, 1, whether the charges are grave enough to warrant continued denial of promotion, where there is any likelihood of the case coming to a conclusion in the near future, Whether the delay in the finalization of proceedings, departmental or in a court of law, is not directly or indirectly attributable to the government servant concerned, and whether there is any likely of misuse of official position which the government servant may occupy after ad hoc promotions, which may adversely affect the conduct of departmental cases, criminal prosecution. My lord, the clause 5 of the OM, exceptions A to E, my lord, will not falls against me, my lord, will not come against me, my lord. So therefore, my lord, may I respectfully submit that kindly dispose of this writ petition with a direction enforcing the para 9 and 10 of the para 9, 10, 12 of the WPC number 98, order pass on WPC 98 2022, my lord. Instead of keeping the matter pending, at least he will get the selection grade. Then thereafter he will agitate, my lord. Subject to the consent of my learned brother Subbu Tapin, the senior government advocate.
No, things that we would like to know also what has happened after this,
Correct, my lord.
isn't it?
Correct.
Instead of straight away saying that dispose as per the directions, what has happened after
Fine,
this
my
order?
lord. In that event, my lord, may I request, my lord, kindly to consider my interim prayer.
Let him
Pendency
get-
of the writ petition
let
shall
him
not
get
be
the-
bar upon the state respondent to give effect to the order dated order dated, my lord, 16/3/2023.
Yes, Mr. Tapin.
DCC notice may be issued also. And so interim is concerned also. Now the situation is changed also. That point of time also. If the criminal proceeding or departmental proceeding, if that is not completed within 2 years also, in that case also ad hoc promotion has to be given. That is the observation made by the this law court in that particular litigation also. Now situation has changed also. As my friend has submitted the case, that criminal lawsuit trial, that is the end. And then,
That has come to an end, my lord.
and therefore there's no question. So ad hoc promotion. Now the regular promotion has to be given lawsuit. Now DPC held on lawsuit in the year 2018 and 2021. This is the main lawsuit that DPC has been kept in seal cover now. Now that has to be open lawsuit. So therefore, at this is either notice may be issued or lawsuit the representation has been filed subsequent to all this circumstances lawsuit. That is on lawsuit 9/10/2025. Here lawsuit the entire grievances have been also raised by the petitioner. So authority can be directed to consider this representation
In terms
by
of the
taking into consideration
Yes.
the other object.
Where's the representation?
63, my lord.
Here the petitioner has almost various places. I think all the lawsuit owners and all lawsuit. Second circumstances have been missed. Else lawsuit notice has to be issued.
But the petitioner,
Granting interim does not arise.
my lord, the petitioner will be retiring within a period of 2 years, my lord. He has a short life now. Whereas all his friend has been inducted into IS because of this.
Lawsuit may give a time frame to consider these routines.
No, but he also has not interest. He's not interested to approach this court again. After getting the order on 16 March 2023, come more than 2 years later on.
But that's why, my lord, had it been within a period of 1 year, he came back to me. I could have very well advised him to invoke the contempt.
No,
but he was sleeping over his
when I
right.
say he, I mean the client.
Yes.
You, of course, definitely as a lawyer, if somebody comes, definitely advise. But this writ petitioner himself, he got an order, court said that you consider his case.
But that
he should have been prompt.
No, well, there was a representation we have submitted to them.
Otherwise, so far, prayer number one is concerned.
Representation has come only just recently in October.
This has a reference of previous reminder that we have given.
Since now the trial has been concluded, Lordship, in his favor. So in that view, Lordship, the authority can relook on the Lordship seal cover.
See, your representation speaks about everything. So we direct them to dispose of this. This has been addressed to whom? Commissioner and Secretary Personnel.
Correct. The Chief Secretary. The Commissioner Personnel. They are the controlling, gather controlling authority.
Where's the first read petition?
Oh, first.
Have you enclosed the order? No.
Order has been enclosed, my lord.
Where's that?
Page 34. That is reproduced in the second round of listing.
74.
No, my lord, 34.
34.
Correct.
What was the
Petition was in connection to the suspension law.
suspension, my lord?
It was not about this Lordship, the promotion. He was kept under suspension laws.
What was the direction?
Direction was to reinstate.
Then the second read petition was regarding
Regarding ad hoc promotion, my lord, due to pendency of the criminal case which they have taken. My lord will find at page 57,
Here he has sought for laws promotion.
which we were reading a while ago, my lord.
And today, what are you seeking?
Today I am seeking for the promotion only, my lord.
The seal cover is still not opened.
No, not open.
That is the reason behind is the proceedings are still pending, isn't it?
Yes. And now that exoneration, I have been exonerated from that criminal case, except for one departmental proceeding which they have initiated in 2019, my lord. And till today, it has not been concluded.
Can the seal cover be opened as on today?
That's why, my lord, seal cover only in respect of senior grade to selection grade can be opened.
Is that what you have mentioned here?
Yes.
In your representation?
Yeah, no, my lord, it was a general representation that I should be given ad hoc promotion.
That's why. See, the concept of having seal cover is because there's a DP pending.
I forgot to bring that Janaki Raman judgment, my lord, 1991. That
No,
has dealt with.
The DP pending requires that the matter has to be kept in seal cover. When will it be open? After the DP is completed. And once the seal cover is open, if they find that you have been recommended, then you get the benefit of the recommendation, whatever was given to you.
But my lord, this has further been simplified. This jurisprudence has further been simplified by this OM, which I have annexed at page 65, my lord, 14.9. That is what has been produced in para 6 of the judgment which we were reading, my lord. Page 67, my lord. OM, the operating portion is at page 67. My lord, I'll assist reading out since I don't want to pain my lord without a specs. 5, my lord.
No, it's okay. It's okay. It's all right, Mr. Tara.
Fine.
You have already read it earlier.
Right. My lord will also.
So in this case, under this condition A, B, C, D, E, if none of these are attracted, the government can consider giving you the ad hoc promotion.
Only one consideration is that a officer should not be under suspension. But in my case, I have been reinstated. My lord will find on the top of the paragraph 5. Last three lines. In such a situation,
We'll dispose it of.
yes, ma'am.
Please write down. Heard Mr. T.T. Tara, learned counsel for the petitioner, and Mr. S. Tapin, learned senior government advocate appearing for the respondents. Stop. Having regard to the projection made by the petitioner, comma, the writ petition is taken up for disposal at this stage. Stop. Next para. This is the third time the petition is before this court. Stop. The first writ petition, being WPC number 143 of 2020, challenging the prolonged suspension of the petitioner, was disposed of. White order dated 10/2/2021. By directing the reinstatement of the petitioner in accordance with law. So thereafter, the petitioner filed his second writ petition, that is WPC number 98 of 2022. Praying for a direction to the respondent authorities to grant him ad hoc promotion. Since the departmental proceeding drawn against him could not be completed for a period spanning over 2 years. Stop. The writ petition was considered and disposed of. White order dated 16/3/2023. By directing the respondent authorities to consider the case of the petitioner for ad hoc promotion in terms of the office memorandum dated 14/9/1992 and more particularly clause 5 thereof. Apparently, since no steps had been taken thereafter, the petitioner is back. The petitioner has filed the petitioner has filed the instant writ petition. Stop. Next para. Mr. T.T. Tara, learned counsel for the petitioner, submits that since the petitioner has already been reinstated and no longer under suspension, comma, there is no impediment on the part of the respondent authorities to consider his case in terms of clause 5 of the office memorandum dated 14/9/1992. Stop. He submits that the criminal case initiated against the petitioner has also ended in his discharge. He is also ended in his favor. In other words, the court had discharged him from the charge. White order dated 10/2/2022. Passed in PCA case number 1 bracket DV/2019. Under the circumstance, the learned counsel submits that there cannot be any reason on the part of the respondent authorities not to consider the case of the petitioner in terms of the said office memorandum. So he submits that before coming to this court, the petitioner had submitted a representation before the Commissioner and Secretary, Personnel Department.
Online.
Is he a respondent here?
He's respondent number 1.
2.
2.
Bracket respondent number 2. On 9/10/2025, bracket annexure 6. But the said representation also has not been considered till date, and therefore the petitioner, having no alternative, is before this court once again. Next para, considering the above grievances projected by the petitioner and having regard to the fact that this court had dealt with the issue in WPC number 98 of 2022 by passing an order dated 16/3/2023, and also having regard to the fact that the representation of the petitioner dated 9/10/2025 is also pending as on date. And therefore, instead of keeping the writ petition pending, the same is disposed of by directing the respondent's consent, more particularly respondent number 2, to consider and dispose of the representation of the petitioner dated 9/10/2025 in accordance with law, but keeping in mind what has been directed in the earlier round of litigation, that is WPC number 98 of 2022, as expeditiously as possible and preferably within a period of 4 weeks from the date of receipt of a certified copy of this order. Grateful.
Item number 5.
Please, my lord. My lord, here the petitioners are basically seeking compensation. Compensation, land compensation.
Okay.
Though, my lord, that award has already been passed, and out of the 80 kilometers, my lord, up to 60 kilometers payment has been made, man. These petitioners, my lord, they are within the 60 kilometer to 80 kilometer stretch, my lord, in the Talia Tato Road, my lord.
20 kilometers.
20 kilometers.
Total stretch is 80.
80, man.
And payment has been paid up to 60.
Up to 60, man.
Okay.
That is my basic case, my lord.
Okay. What is the purpose?
Purpose is for upgradation of road, my lord.
What is the name of the road and which area?
Talia Tato, my lord. Talia to Tato Road, my lord, in Upper Subansiri district, my lord.
Taliha Tato Road.
Yes, my lord. The notification, my lord, preliminary notification is at page 35, my lord.
35.
My lord.
What has been invoked otherwise? Provision?
The emergency clause, my lord.
Under the
Yes, section 11 read with section 41, my lord.
Act of 2013.
2013, my lord. Lara Act, my lord. This is page 35, my lord.
So,
Issued under section 11(1), read with section 41 of the right to fair compensation and so, my lord, invoking the urgency clause.
11(1) and 41.
41, my lord.
And why that 20% is not being paid?
My lord, that because now we have submitted a representation, my lord.
Is
Now,
there any provision as such under the Act that it can be in that piecemeal?
no, my lord, there is not as such, my lord. The only response, my lord, since the acquiring authority is the deputy commissioner, we had submitted a representation, man. The deputy commissioner forwarded that representation to the requiring body, man. That is the BRO, man, Border Road Organization. And now they have replied that the DPR is not yet sanctioned, my lord. It is at page 58, my lord, the ground, my lord.
There was a notification, preliminary.
Preliminary notification.
Then there was an addendum.
Yes, addendum was there, my lord.
What was the requirement for having an addendum?
First, if your lordship would see it at page 35, it is 401 hectares, my lord.
So area has been modified.
Modified, and the reason is that the DPR has been sanctioned, my lord. If
400, where is it?
if your lordship
401.
401, my lord.
This has become now.
Now it's at page 37. That is the addendum, my lord.
What is it?
Second paragraph, my lord. And whereas on ground survey, the total area of land required for the said purpose is slightly varied from the earlier notified area of 401 hectare, 980 so and so square kilometers due to the reduction in the total land acquisition as per approved DPR, my lord will see, man. As per the approved DPR as sanctioned by MOT, Government of India, white so and so, dated 15/3/2024.
Modified area is 278.95 hectares.
In the second paragraph, it says that DPR has been modified after the issuance of the preliminary notification of 7 February. Now that was new DPR was sanctioned, my lord, at 15/3/2024. Now the only reason the MOT, sorry, my lord, the requiring body, the BRO is saying that DPR has not been sanctioned, my lord, which is contrary to the records, my lord, the notification itself. Now in this addendum, my lord, that out from the 401, it has now been reduced to 298 78.95 hectares. This is addendum. After that, my lord, the procedure was followed, my lord.
After that,
public notice was issued, objections were heard, and finally that award was passed, my lord.
Where is the award?
Page 47, my lord. This is the forwarding letter, my lord, Annexure 7. Page 47. To the Director Land Management, so and so submission of draft compensation award. And next page 48 is the award. Here the names of the petitioners, it starts from page 80, serial number 86 up to 132, man. In this award, man. Now up to 85, serial number 85, the payment has been made.
What, according to you, could be the reason?
The reason that after our submission of the representation to the deputy commissioner, my lord, the deputy commissioner forwarded it to the BRO. Now BRO has written back to the deputy commissioner on 31 October 2025, my lord. That is at page 58, my lord. 58.
Yes.
To the deputy commissioner, approximately so and so. Forwarding of representation. Sir, please refer your good office letter so and so dated 7 October, under which representation of so and so, chairman of so and so, white letter number dated 29 September has been received. In this regard, it is intimated that the DPR for construction of Talia Toto Road from kilometer 60.250 to kilometer 80.960 has already been forwarded to the competent authority for approval sanction. The land compensation said stretch is pending due to non-sanction of the DPR, and the same shall be processed after sanction of DPR for stretch from kilometer so and so to kilometer so and so from the competent authority.
Due to non-sanctioning of DPR.
Yes, ma'am.
So otherwise, up till 60, DPR has been sanctioned.
Otherwise, my lord, if your lordship would come back to the addendum, my lord, at page 37, my lord. And my lord, it is very surprising, my lord, that the DPR sanction is made in this piecemeal manner, man. It's page 37, my lord.
Yes.
Second paragraph, my lord.
Second paragraph.
Yes, second paragraph that I just read, man. And whereas, my lord, on ground survey, the total area of land required for a said purpose is slightly varied from the earlier notified area 401 hectares so and so due to reduction in the total land acquisition as per approved DPR as sanctioned by Ministry of so and so, MOT, Government of India by so and so, file number, everything is there and dated 15/3/2024. So this, my lord, communication from the BRO is, my lord, contrary to this, my lord. In there, at least, because earlier that was 401, my lord. 401 hectares. And after the approval of this DPR, approved DPR, my lord. And the DPR was approved on 15/3/2024, my lord, after the publication of the first preliminary notification, my lord.
So this
Yes, ma'am.
approval of the DPR 15 dated 15/3/24
My lord.
is only in respect of that 40-kilometer stretch,
No, my lord will say,
60-kilometer stretch.
no, my lord will down below, my lord, the table, my lord. It is from 28 kilometer to 80.960, my lord. Location, my lord, proposed so and so from kilometer 28.543, my lord, and down, my lord, to kilometer 80.960, my lord. Now, since it's under the emergency provisions, my lord, after the publication of that public notice, already possession has been taken, my lord. The act also says at least 80% should be paid, my lord, before taking possession, my lord. Now they paid up to serial number 85, my lord, up to kilometer 60, my lord. Rest, my lord, they are not paying, my lord.
Yes. You are there. Another, I'll be appearing for respondent 3 to 5. Here, would like to take instruction. Because if it's the requiring body, the BRO will have to sanction the amount. Requiring body. Or requiring body. Requiring body has to sanction the amount, deposit the amount. Requisitioning body. Yes. Okay. BRO. Not just a piece of the environment, also for the petitioners. What's that? The plan of the petitioners are will acquire under the emergency clause of the right to their dispensation. Advancements in medical Rehabilitation and Resettlement Act 2003. From Taliha to Tato under Paying Circle, Upper Subansari district. Stop. Preliminary notification was issued on 7/2/2024. And thereafter, an addendum was issued on 28/6/2024. Modifying the total area required to 278.95 hectares from the original 401 hectares. The same was done according to the authorities in view of the approval given in the DPR. For the same area. But so far, payment has been made to the landowners whose name appeared in the serial number 1 to 85 in the award. Whereas the petitioners whose name appeared from serial number 86 to 132 have been deprived of the payment. And the reason given is that the same is due to non-sanctioning of DPR. From KM 60.250 to KM 80.960 by the competent authority. So the same was communicated by the Assistant Executive Engineer bracket civil for the 77 Road Construction Company bracket GREF to the Deputy Commissioner Upper Subansari District Doparijo bracket annexure 10. Before annexure, you just add this again. Doparijo on 31/10/2025 bracket annexure 10. Next para, in view of above, issue notice of motion returnable by Movix. Mr. N. Ratan, Learned Additional Advocate General, Arunachal Pradesh, accepts notice on behalf of respondent numbers
3 to 5.
3, 2, and 5.
3, 4, and 5.
3, 4, and 5. While your name? T. While Mr. T. Meto, Learned Counsel appears and accepts notice on behalf of Mr. M. Kato, Learned DSGI, who represents respondent numbers
1 and 2, madam.
1 and 2. Anyone left out?
No, madam.
Stop. Notice is therefore complete. Stop. The petitioners shall furnish requisite copies of the writ petition to the learned counsels appearing today for the respondents within 2 days. List again after 4 weeks.
Obli.
Item number 6 and 7.
6 and 7. Is the part matter. Means the connect 6 bridges that petitioners are planning for awarding of the 6 bridges for execution.
Why was it postponed today?
That the certified copy, the positive of plan as well as the certified copy of the filing of it, or because of the certified copy.
Correct. Certified copy.
I have
And what else?
and I couldn't complete my examination.
Okay.
I'll make it very but basically the writ petitioner is writ petition. The argument is structured on 2 points. Firstly, since the
My lord, I'd like to interrupt, my lord. My lord, I don't know what sort of record my learned friend has submitted. Now, the question was under section 63, if you produce some photostat copies, that will have to be certified by an officer who is handling the machine.
Yes.
Now, that is, my lord, I will take your lordships to a decision in the appeals court. Now, if my learned friend has done it, my lord, we have a right to see whether it was done in that manner. If it is not done, my lord, it cannot be looked into. It's not a question of certified copy. It's a question of compliance of section 63 of the BSA.
It is a certified copy given by the Under Secretary of the department.
Lord, they are not understanding the matter in the legal parlance. My Lord, I'll just take your lordship a decision, give that.
It's a code of records. It is not a criminal trial.
This is not a question of law. Give me
I
that.
do understand.
You are not understanding. That's the reason I'm having the trouble to make, my Lord, all this submission.
You just point out the
Oh,
section.
Pandit Rao.
What section you're saying? BSA?
Yes, it is here.
That's your question.
Mr. Datta,
My Lord.
see, whatever objection you have to place, you place it.
My Lord, if your
Let him,
lordship,
let him make a submission.
yes, yes.
Then
My Lord,
you place your objection.
can I see to that, my Lord? What
What?
sort of record he has given?
So these are records called by the court.
My Lord. Now, whether it is in terms of section 65B,
And
my Lord,
leave that to the court.
my Lord,
You
No.
want to explain to the court what is that section?
My Lord, if it is in compliance of that, my Lord, this is the end of the matter.
No, if you are to satisfy yourself, what is the necessary for the court to sit at all?
No, my Lord, I am not on that.
Then-
My Lord, if the records which he has given, it is not in terms of 65B, my Lord, this is not admissible. In
All right, you make your submissions when the thing comes.
Yes, my Lord.
65, section 65B.
Of the Evidence Act
Evidence Act
Hmm.
and section 63 of BSA.
is a new one, my Lord.
Hmm. No, we'll keep that in mind.
Yes, yes.
All
My
right.
Lord, and the decision which I am relying, that is 2027 SCC, page 1,
2020.
7 SCC.
You hand over that copy to me.
Yes.
If that copy is available.
Copy.
You indicate the
My Lord, paragraph I am indicating
61
25, 26,
and
29, 33. Right there, no? 33, 34, 35, 36, and 66.
This 2020,
2020.
volume 7,
7 SCC, page
1.
Yes.
Paragraph numbers,
25, 26,
then
29,
Hmm.
33,
Hmm.
34, 35, 36, and 66, no? 61.
66 and 61 also.
61.
61.
61, not 66.
Okay.
These are the relevant paragraphs.
Okay. This is on section 65B.
65B. And they are required to give a certificate, my Lord, that is the schedule under section 63 4C of BSA. Book.
All right. Let him submit.
Yes.
Hmm.
My submission that
Hmm.
the argument advanced by the petitioner, which basically is structured on 2 points.
Hmm.
Firstly, they say that in the file, approval was given by the Honorable Chief Minister, and therefore it is a cabinet decision, the decision of a cabinet. Once a cabinet decision has been taken, it cannot be changed
Hmm.
without routing again to the cabinet.
Hmm.
Firstly, that's such. And the second ground is that there, by the doctrine of principle of promissory stop,
Hmm.
since the petitioners was asked to do the work. We are bound to award the work. Now, my lord, in the first point, whether the approval given by the Honorable Chief Minister at page 44 of the writ petition wherein the UO note number 530 dated 17/9/24 has been mentioned, and the approval of the Honorable Chief Minister is there by endorsing his signature, whether that can be called a cabinet decision. First question. Here the approval is obviously of the Honorable Chief Minister, but he is also the concerned minister of the PWD. And apart from the Honorable Chief Minister's signature, there is no other minister's approval. This first my submission will be that this approval cannot be termed as a cabinet decision.
Okay. Then
my lord, this was approval in the file. Any approval by a minister has to be sanctioned. The sanction has to be done by a committee, cabinet subcommittee, for sanction of any project. Now, this project for administrative approval and expenditure sanction, this was initiated in a separate file. In a separate file, because even though this has been approved by the Honorable Chief Minister, but for administrative approval and expenditure sanction, this has to be approved by the subcommittee consisting of the minister concerned, the finance minister, and the Honorable Chief Minister.
Okay.
Now, therefore, from the records, since
any specific provision you would like to rely upon that?
no matter, as per the rules of executive business, any matter concerning the finance of the department, finance of the state.
So which rules?
Rules of executive business,
Not the rule in particular. Rule 1, 2, 3, 4.
Madam, in the schedule, if rule
Page 202.
rule in the schedule, madam, at item 13, madam. Any proposal which affects the finances of the state which does not the consent of the finance minister. If we read rule 8, 10, and 14 together, then it is required that for any financial sanction mark, it is not only the chief minister alone who can directly sanction. In fact, this is not even the pleaded of the writ petitions.
Yes, go on, please.
It is not even a pleaded place of the petitioners, but they have just advanced the argument that since cabinet decision was taken, after the approval of the Honorable Chief Minister, cabinet, it is a cabinet decision, so the authorities could not have changed the term, the conditions of the cabinet decision. That is the basic argument advanced, because the approval, it says the contract will be awarded to the petitioner by way of an extended tender. That is the approval. That was approval by the Chief Minister. But what actually has been done? The administrative approval and expenditure sanction, when it was given, there are certain terms and conditions. How to execute, because it is by the finance department's conference, the terms and conditions are given. How to execute the work. Now, what the petitioners, they have annexed in page 65, it is not legible at all. But at page 65, it might look many terms. Only the memo number, the last handwritten number, 1965 at page 65. I will see in the top. The annexure 11, page 65.
There's a type copy.
I'll come to the type copy. But only to show that petitioner, they have rightly annexed this memo number, this sanction order, administrative approval. 1965, that is clear. Rest conditions are not legible. In condition 12, at page 68, which is the type copy. To my respectful submission, this is not the true version of the type copy. Here, if my lord reads my lord, condition 12, it says that the execution of works, schemes, projects, and procurement of items, material, furniture, etc. should be done strictly as per the provisions of DFR, DFPR, CPW manual, etc. All the financial rules and regulations, the guidelines and directives issued by the Government of India, Ministry of Finance, Government of India, Administrative Ministry, Government of India, CBC, and Government of Arunachal Pradesh in this case. Now, my lord, there are certain conditions missing here. Now, if my lord comes to my affidavit filed by the respondent 1.5 at page
127.
I'll start. That's 127. I'll come back. Page 130. They have annexed the corrected copy. Page 130. Memo number, my lord will see.
No, they have means who has annexed this?
We have annexed this.
Then why did you say they have annexed?
They have annexed in the writ petition what they have annexed, and the type of copy, the condition of at serial number 12, which I have read, it is not the same.
No, that you've said, I understood. But this page 130, you said they have annexed. But this is your counter affidavit.
Yes, sir. No. The same they have annexed, but in same sanction order they have annexed, but they have, since it's not legible, they have typed out the conditions in serial number 12, it is different.
Same. You compare it, whatever is typed.
Yes.
So copy what you have annexed.
Yes. My lord,
No,
serial number 12.
Also it says.
The execution of works, schemes, projects, and procurement of items, materials, furniture, etc. should be done strictly as per so and so, so and so, so and so. All the financial rules and regulations, the guidelines and directives issued by the Government of India, Ministry of Finance, Government of India, Administrative Ministry of Government of India, CBC, and Government of Arunachal Pradesh in this regard.
Correct.
From time to time should be followed in letter and spirit without fail. If we compare it, then further, the process of tendering and competitive bidding should mandatorily be followed and complied with as emphasized in the GFR, DFPR financial rules and regulations and the conditions, guidelines, circulars and directives issued prescribed by the Government of India, CBC and the Government of Arunachal Pradesh. The sentence, the process of tendering and competitive bidding should mandatorily be followed and complied with as emphasized in the GFR, DFPR financial rules and regulations and the conditions, guidelines, circulars. These are missing now. The entire argument they advance is also on what basis?
So if this is missing, then what happens?
Here it says about that this work should be mandatorily advertised and the process should be compliant. Tender should be done. This is the condition. Tendering process for these 6 bridges, there should be a tendering process.
So here there is an approval.
Yes, approval, but the condition, approval is another thing. The condition, what is given is it should be mandatorily, tendering process should be complied. And even the government notifications, the CBC guidelines also talks about tendering process. Now, I'll take your lordship. Their entire argument at page 127, 127 of my affidavit. This, in fact, the argument advanced by the petitioners are based on the condition in serial number 12 of this sanction order, which was manipulated, I'll respectfully say. My lord will kindly see the initial conditions are very the same. The execution of works, schemes, projects and procurement of items, materials, furniture, etc. should be done strictly as per the provisions of GFR, FPR, CPDB, manual, so and so, etc. All financial rules and regulations, the guidelines and directives issued by the Government of India, Ministry of Finance, Government of India, Administrative, so and so, CBC and Government of Arunachal Pradesh in this regard from time to time should be followed in letter and spirit without fail. The work shall, this line, the work shall be carried out through extended tender as per approval of the government by number 530 dated 17/9/2024. My lord, this is actually the basis of the entire argument. And this condition, how this is what I'm respectfully submitting. This is a manipulated document. This was because of some manipulation while the sanction order was signed. For that, my lord will kindly see the records. How things has happened.
No, see, one thing is that if you say that the reason for recalling this work is because of manipulation, you should have plain order that there has been some manipulation.
No.
We don't intend to go.
That's why the corrigendum was,
Hmm?
there has been some mistake. The corrigendum was issued.
Where's the corrigendum?
Corrigendum is at
129.
129.
Last
Immediately after coming to know, rectification was done, corrigendum was issued.
Hmm.
The administrative approval and the expenditure sanction number so and so. My lord will see the memo number here, 1635, dated 18/3/2025, relating to so and so, under so and so, with estimated cost of so and with expenditure restricted to so and so for the CYF is cancelled due to presence of some unintentional errors in serial number 12 of the above modified order.
What is cancelled?
This earlier one, at 127. My lord will see the memo number in the top. It is 1635 in the top.
1635 is cancelled.
Cancelled because there is some unintentional errors in serial number 12.
Okay.
This condition that what is the error is that the work shall be carried out through extended tender as per approval of the government.
Corrigendum and improvise. There was no interpolation of the.
I will.
There is including.
Including here, you have made a different statement. What is it?
Including you have anything about this. My lord has seen.
So what is the effect now?
Now, the entire argument, what the petitioners, they were harping on that since the by your note number 530 dated 17/9/2004, 24, the Honorable Chief Minister has approved by way of extended tender. They inserted these conditions in this, which was not to have been inserted. And the entire case is that once it has been approved, this should have, and this could not have been changed. This condition could not have been changed. The authorities could not have acted contrary to this, the approval to this condition. Now, if my lord kindly comes to how the
corrigendum is not challenged, is it?
Not challenged. The subsequent sanction order dated 19th same date. The memo changed 1965. The earlier memo is 1635 at page 127. Top. 127 top.
Yes, 1635. Then the next memo is?
The next memo is 1965. Same date at page 130.
130. Read petition.
No.
From the counter.
Yes. I'll come to only my counter. I have annexed only three documents.
We have challenged that.
I will try to clarify the entire matter by these three. Memo number at 127, my lord will see 1635 on the top. Corrigendum is there. And then at page 130, date, everything is same. 1965 memo number has been changed. And in the corrigendum, the memo number 1635 has been cancelled. My lord has got what I'm trying to say.
Yes, I've got
Because
it.
the-
Only that memo number is different now.
Yes. And
Now-
the condition,
And the condition at serial number 12.
yes, in the cancelled memo number,
Can you come up with the same date again?
yes, same date, but sign on, this,
Sign on
this is signed on 21
21 subsequently.
subsequently.
But you
The
have borrowed,
earlier one is signed on
Mhm.
18.
but digitally signed on 19/3.
Yes. Then digitally signed by the
Issued on 21.
issued on 21. Digitally signed by the 19. The earlier one at page 128 is.
See, we'll do one thing. Can we continue tomorrow? There's no time. I'm having some difficulty.
Yes.
I understand.
Better, your lordship take tomorrow, my lord. Your lordship is heavy.
Tomorrow.
I've had 3-4 glasses now.
In fact,
So stomach is full with warm water.
it can be day after tomorrow then.
Day after tomorrow.
My lord, day after tomorrow, criminal appeal is fixed. Your lordship.
No. Tomorrow.
No,
is-
day after criminal. Tomorrow it is also fixed, but there is a
That's why-
bund call going on. Then
That's
that
why the same
Apu Appa is also involved in this case now. Tomorrow.
Let it be taken tomorrow because
Any news about tomorrow?
Tomorrow.
tomorrow is okay.
Tomorrow is okay. We take a chance, brother.
We shall take a chance.
In fact, my lord, I have some personal. I was supposed to go back home today for a funeral, and therefore I pray for day after tomorrow. In fact, I stayed there only to complete this part.
I came for this purpose only, my lord.
That's why I.
Tomorrow.
Datta, I think you have done your part already.
My lord, but
Now
then,
you want to bring
yes,
that,
your lordship is very correct.
DCA and all that.
But
Then
then,
you can appear through RVC also if you want to.
uh,
We have heard you actually. I think
Yes,
you have
your lordship
given
is-
your detailed submissions.
right.
And plus, Mr. Tara is here also
Yes, yes.
in case of any eventuality.
Lord, that link is very poor there from Guwahati to Itanagar.
Definitely, it's poor. I've seen. The sound also is very bad.
Yes, not audible even.
I pray day after tomorrow.
But tomorrow, what difficulty you have?
My lord, I am planning to.
Go out of station.
Yes. I have
This
to-
bench is available till Friday only. That's why.
I have to attend a funeral.
Okay, man. That bereavement.
It's day after tomorrow as a person. I stay back to complete this.
Next day, no?
Okay.
Day after. Tomorrow, it is, no, he says he has to attend funeral, sir. So that he cannot.
Okay. Yeah.
Day after tomorrow.
Fine.
Point involved.
Yours.
File is.
You give me the seal cover. You give me the seal cover today itself. Let it be here in the records.
Yes. I'll just.
And I'll take into account also what Mr. Datta has said.
Yes.
So we'll see as and when the time comes. You write one line, list again day after tomorrow, give the date
9th.
as part heard, will be
10th.
on 10th of December as part heard. And as the first item in the admission column.
Yes. Much obliged.
Any other matters remaining?
Item number 11.
11.
Yes.
Sorry. Or you produce day after tomorrow only, you take it back. Not it give. Yes.
Oh, my lord, due to paucity of time, yeah, counsel of the department has left. And
Okay.
So with my permission, I thought time will, there will be a paucity of time. So
Okay, so when do you have it? Give a date.
this matter after 2 weeks, my lord.
2 weeks, all
Yes.
right. 2 weeks, as per by the parties, list this matter again after 2 weeks.
Item number 17.
Contempt.
Contempt, Lordship. They are not depositing the compensation amount, Lordship. There is a clear direction from this honorable court.
Why is it listed today for orders?
For orders, Lordship, they were supposed to take instruction, Lordship. In fact, they have filed their affidavit also, Lordship.
My lord, we have taken instruction. As per the instruction, the matter is pending for approval of compensation at DGBR level.
Where?
DGBR.
DGBR.
Yes, my lord.
Really?
Yes, my lord. So 4 weeks time may be given.
Is that your instructions in writing?
No, my lord, as per instruction instructed by my senior counsel.
Okay, we'll record that. This again on opening.
Yes.
It is submitted on behalf of Mr. M. Kato, learned DSGI, that the compensation amount is pending for approval of the
Approval of compensation at DGBR level.
pending approval at DGBR,
Yes, my lord. Director.
at the Director General of Border Roads level,
Yes, my lord.
and that some more time may be granted to come up with the up-to-date status. Your good name?
And Sora. And Sora.
Okay, in the beginning part you write. What did I say? DSGI, na? DSGI by Mr.
And Sora.
N. Sora,
Yes, my lord.
Learned Counsel. That's one. So the rest I got it. List again, when?
My lord, after 4 weeks. My lord.
On 21st of January? On which date the learned DSGI shall inform the court about the up-to-date status. All right.
Item number 19.
19.
Last item.
Hmm.
It is.
Mr. Pangi has left. You are there? When
Lord,
you wanted?
Leading counsel will be appearing through BC, but it's not connecting.
Today not possible, na?
Then,
We'll have a date.
day after tomorrow, Lordship.
Day after tomorrow.
Yes.
Is there any urgency?
18.
Hmm?
Item number 18.
Mr. Duncan is there?
Yes, I'm for respondent 6. 1919.
Hmm? Who will be appearing through RVC?
That was, I think, for item 18.
Oh,
18 was a.
oh, 18. Not this, na?
Yeah.
Because hearing, preferably if they appear physically, it's better. Item
Okay.
19.
Morning ko adjourn kiya to. 18 was adjourned, Lordship, in the morning only.
Okay. So this is 19.
Yes, 19.
When should we fix it?
But I think Mr. Pangu was saying that after 2 weeks.
2 weeks then?
Yes, sir.
That's paid for by the parties. Now, this is a 2018 matter, no doubt, correct. But it came as a review.
Yes.
Again, it has been
Yes. Yes.
back to square one. That's the thing.
So 2 weeks.
2 weeks, okay. That's paid for. Let the matter be listed again after 2 weeks.
Much about it.